this morning?
Good.
Is there any further witnesses on behalf of the state of Ohio? There's a little maze you have to, I should put yellow tape down here.
To the witness stand if you can.
You raise your right hand. You solemnly swear, affirm under penalty of perjury, your testimony in this case will be the truth, the whole truth, and nothing but the truth.
I do.
Have a seat. Pull yourself up close to the microphone. And you may inquire.
Good morning.
Good morning.
Would you tell the ladies and gentlemen of the jury who you are and what you do?
My name is David Loomis. I work for the Ohio Organized Crime Investigations Commission, which is a section of the Ohio Attorney General's office, and I'm a senior audio forensic video analyst.
And how long have you been with the Attorney General's office?
About 8.5 years. It'll be 9 years in August.
And can you tell us a little bit about the Organized Crime Investigation Commission, the unit in which you work?
Yes, the commission runs a series of task forces across the state. The lab was created to assist with the task forces for any of their audio and video forensic needs. We clarify audio and video as well as create courtroom presentations.
So you do that for agencies across the state?
That's correct.
Any department can come to you and say, we need your help with something, is that right?
Yes, that's correct.
And what kind of training do you have to enable you to do your job?
I have a bachelor's degree in media arts and animation. The media arts side has to do with audio and video production. I also have a certification through LEVA, which is the Law Enforcement and Emergency Services Video Association, which deals with the forensic side of what we do.
And you said you review videos, you enhance. What sort of tools do you use in order to do your job?
Primarily, we use the Adobe products. We use Adobe Premiere, Adobe Audition. We also have some products that are specific to forensics, such as AMP5 and Axon Investigate.
And this is what you do full-time?
Yes, it is.
You were doing this back in 2018 and 2019 then?
Yes, that's correct.
And have you testified before in the field of forensic video analysis?
Yes, I have.
How many times, if you recall?
I've testified about 16 or 17 times and qualified as an expert, I think, 6 times.
Throughout the state of Ohio?
Yes, that's correct.
And you've testified as an expert in this very court, is that correct?
Yes, I have.
I'm going to show you what's been marked as State's Exhibit E1. If I may approach you.
Yes, ma'am.
Do you recognize that document?
Yes, I do.
What is that?
That's my curriculum vitae.
And does that list all of your educational experience, your training specific to this field, accomplishments, things of that nature?
Yes, it does.
You were asked to do something by Columbus Police in this case, is that correct?
Yes, that's correct.
What was it Columbus Police asked you to do back in 2018?
They provided me with some surveillance video, and we're trying to get, be able to better see some events going on inside of a car parked outside of a building.
Right. And how is it that they came to you and said, we need you to do this? Like, what's the process?
The process is they can come to our office, they drop off the evidence along with a submission sheet. They may just write their request on the submission sheet. Sometimes they'll talk to us directly and just tell us what they're looking for.
Right. And do you recall the date that you were asked to look at this video?
It's been a while. I remember it being submitted, yes.
All right. Let me show you State's Exhibit 2. Could you tell us what State's Exhibit 2 is?
This is a report that I prepared for the initial analysis that I did for this case.
So that's E2. I may have just said 2. And does that state the date on which the request was made?
Yes, it does.
What date was that?
That was September 18th of 2018.
And who made the request?
Detective Gregory Shepard of Columbus PD.
And you said he asked you to see if you could clarify some surveillance video, you called it.
That's correct.
What did you do at that point?
At that point, our process is we gain custody of the evidence. In this case, I believe it was a flash drive, like a thumb drive that had the video on it. We make an exact working copy so that we never change or modify the original. Then we review it, see what can be done with it, and create a work product that we hand back to the detective. In this case, the video that we were looking at, it was not very high quality video. There wasn't a whole lot that could be done with it. I was able to brighten it a little bit and create a region of interest that's enlarged. The enlargement itself is not a clarification. It just makes it, when we present it on the screen, it makes it a little easier for you guys to see, but it does not bring out any additional detail.
So it doesn't change the information that exists, the picture. You're just trying to brighten it up a little bit and bring it bigger.
Yes, that's correct.
Let me show you a few more exhibits. Exhibit E3 and then V1. Let's start with E3. Could you tell us what that is?
This is the chain of custody report that is prepared by our evidence custodian.
And what is that form used for?
It just shows who has custody of the evidence and at what time.
So that marks when it comes in, when it goes out,
Yes.
and it's kept safely in your office then?
Yes, that's correct.
So if somebody wants to see that or do something with it, they have to sign out and it would be on that chain of custody form, is that right?
Yes, that's correct.
What, if you can tell us, is Exhibit V1 in the envelope?
V1 appears to be the evidence that was originally submitted to me on the flash drive.
So that would be the building video that Detective Shepard brought to you?
Yes, that's correct.
And you don't go out to scenes and collect video and things yourself, is that right?
Not usually. Very, very rarely do we actually go out to a scene.
So when you're brought video on some sort of media, what do you do to verify that it's intact, that it's not compromised?
To verify that we have an exact working copy of what we have, we run what's called a hash on the file. It's kind of like a digital fingerprint or like a verification code. So it will create a hash for the source file and a hash for the destination file. And if we know that those two codes match, then we know that we have an exact copy.
Right. If I could see State's Exhibit E3 back, please. I'd like to put this on the screen. Can they publish this now?
You may.
Okay. State's Exhibit E3, this is the chain of custody report you referenced?
Yes, that's correct.
Okay. And so we can see we have various names, custody of, times. This is the information you were referencing when you said the property comes in and out and it's documented?
Yes, that's correct.
And if I may see another exhibit here, please. Thank you. E2. Now, what was E2? Did you
E2
publish
is-
your report?
Yes, that's the report.
Okay. And you note you inspected item 1 to be sure no physical damage exists. Is that the item that you have in front of you there, V1?
Yes, that's correct.
Generate and save a working copy, convert proprietary video to universal format. Is that what you've described so far?
Yes.
And you have apply software filters to clarify video. Could you explain what that means?
Yes, in this case, the only software filter that was applied was a levels adjustment, which just brought up the brightness a little bit.
Okay. And produce a data DVD of the clarified video presentation. Explain what you did to do that.
Okay, so once I've created the presentation, once I've enlarged and brightened it, I place a copy of that onto a DVD to be handed back to the detective.
And you've mentioned a few terms. Let me move us up a little bit here. Was copied and verified via SHA-1 hash using Quick Hash 2.2. Was that your exact copy process?
Yes, that's the hash algorithm that I mentioned that's kind of like a digital thumbprint.
All right. And you note here that the proprietary .avi video file from item 1 was converted to a universal MP4 video file for processing using the FFM PEG audio video conversion tool. Could you explain that?
Yes, so the Adobe products, a lot of the surveillance video that we get is in a proprietary format. It's not meant to be brought into an editor like Adobe. So we have to convert it to a universal format. Adobe likes MP4, so we tend to use MP4s. FFmpeg is a tool that we use very commonly for this. It takes the video data, makes an exact copy of that data, and just puts it in the MP4 container. So the video itself isn't changed, it's just put it in a new container that our software will handle.
So how do you verify? You said you're converting. How do you verify you're not losing any information?
The process that I used for this one, the command is vcodec copy. It's video codec copy. So it's taking the exact video data and placing it into the new container. We also visually check it to make sure it's intact.
So you said you were able to enlarge, I believe it says 400%?
Yes, that's correct.
In the region of interest. Did you do something to specifically note the area you were enlarging on that video?
Yes, I believe it has a red outline, a red box around it, so you can see. And the enlargement is placed upon the original video so that you can still see it in its original size along with the enlargement.
I'm going to show you what's been marked as States Exhibit B2. Take a look at that. Please tell us what that is.
This is the original work product that I created for this case.
So is that the enlargement?
Yes, that's correct.
And that is just a video. There's no sound with that, correct?
That's correct.
Were you asked by Columbus Police to do anything with audio?
No, I was not.
After you completed that task for Columbus Police, you prepared this report?
I did.
And then what do you do?
Then I call the detective or email the detective, let him know that it's ready to be picked up, and either hand it off to him directly or check it back into evidence where he can come pick it up at his convenience.
And then as you note in your report, on September 21st, 2018, the DVDs were returned to the evidence room with item 1 and Shepard was notified.
That's correct.
And that was the extent of the work done for Columbus Police Department, correct?
That is correct.
Did you then get a request from my office, me specifically, to do some additional work?
Yes, I did.
Do you recall the date of that?
I don't recall the exact date.
I'll show you States Exhibit E4. What is that document?
This is the supplemental report that I created for this case after I was requested to do additional work.
And would that have noted the date that I requested you to do additional work?
Yes, it does.
What date was that?
That was March the 7th of 2019.
So about a year later, 2019?
Yes, correct.
And what were you asked to do?
I was asked to synchronize audio from a cell phone to the original video presentation that I created.
And were you able to do that?
Yes, I was.
Had you not been able to do that, would you have indicated so?
Yes, I would have.
Do you have any association with anyone in this case?
No, I do not.
You don't work for the Franklin County Prosecutor's Office, correct?
Correct.
Or the Columbus Police?
That's correct.
Show you States Exhibit W. You could tell us what that is. If you need any documents, please ask.
Yes, this is the work product that I created after I synchronized the audio with the video.
So how did you go about marrying or syncing the audio and video?
Okay, so in Hollywood and TV, you'll often see what they call a clapperboard, and it has the slate on it. You know, when they've got a camera recording the video and they've got a device recording the audio. They'll put the clapperboard in front of the camera and they'll say, you know, scene 5, take 1, and they clap it. That creates both a visual and audio sync point where you can go in. Then once they bring it back to the editor, you can say, okay, I can see the clapperboard closing at that point. I can also hear it and see it in the waveform on the audio. It allows you to align them. Because we're working with surveillance video and cell phone audio, obviously we don't have a clapperboard. So we have to look for a sync point where we have something we can both see in the video and hear in the audio. In this case, it was a point where we can see a gurney, we can see the wheels lower and hit the ground. So I can both see that in the video and hear it in the audio, and I'm able to see that, also see it in the waveform, so I have a precise point to line it up. The surveillance video can be a little tricky sometimes. That's why I let the prosecutor know, you know, if I can do this, I'll do it. If I can't, I can't. So we look for more than one sync point, and in this case, we had a few, and I made sure that they all lined up. And in this case, there weren't any issues. It was very straightforward. It synchronized very easily.
So you're not just visually looking yourself, you're watching sound waves and some sort of amplification as well, is that right?
Yes, you can see a spike in the waveform where you have a distinct noise.
And you said you found various sync points. Do you recall how many points you found that were obvious to you? Yes.
Yes, I'd have to refer to my report. So I had 4 initial sync points that I lined up, and then an additional 3 after reviewing. And as we've watched it several times, you can see additional sync points.
So after you thought you had it right based on these sync points, how many times do you review it to be sure?
Several. I don't have an exact number, but probably say, you know, between 5 and 10 times just to make sure, and then, you know, reviewing it with the prosecutor, you know, or additional times. So.
And how can you be sure that there's no information lost or there's no gaps or problems here?
With the video, we can look at the timestamp. We could look to see if there's any visual inaccuracies in it. I didn't notice anything out of the ordinary with this video or with the audio, and the fact that they stay in sync with each other helps.
When you review the video itself, we're seeing the counter count in seconds. Are we losing information as that picture plays out? Is 1 second 1 second? Is there any way that there's information we're not seeing?
1 second is 1 second. I believe this video is 15 frames per second. Your standard television video is about 30 frames per second, so you have about half as many images in this as you do in a normal television program. Very rapid things that happen can sometimes be missed by the camera. So it is. I mean, it is possible that a good example that I can think of is just, and not for this case, but muzzle flash. In prior cases, sometimes a muzzle flash will be picked up, sometimes it won't. It's just a very rapid event.
And that's because you only have so many frames per second.
That's correct.
So maybe a 15th of a second is not visible. Would that be accurate, I guess?
I think it's even a smaller fraction than that, yes.
Okay. And with respect to the audio, is there a way to verify that the audio has no gaps in information?
I mean, we listen to it for continuity. Again, it stays in sync with the video. There wasn't anything unusual about the file, and the audio, I believe, is 48 kilohertz. So it's being sampled 48,000 times per second as opposed to 15 times per second. So the audio tends to be more accurate.
So if you have 10 seconds of audio and 10 seconds of video, are we still talking about the same 10 seconds? This isn't like the sound is on a different 10-second time frame than video would be?
That's correct. They're synchronized.
And let's say somehow when you did this synchronization, you were off. If you were off, what's the margin of error here?
I don't have an exact percentage. I would say it's within 3 frames, so it's very close.
So less than a second.
Yes, fraction of a second, yes.
And you said you went over this looking for synchronization points. I think you said you found 7 you listed there. Is that accurate?
Yes, that's correct.
Did you also find others you didn't list in your report?
Yes, I believe as we've reviewed it, we've seen other points where it appears to sync up, yes.
Did you list the most obvious 7 in your report?
Yes.
So you listed the time and the event. Would that be accurate?
Yes, that's correct.
Good. And then I think you said after you did that, you reviewed it about 10 times or many times.
Yes, that's correct.
If you had not been able to synchronize this, would you have told us?
Yes, I would have told you, yes, and we have had cases where we are unable to synchronize.
I'm going to show you State's Exhibit V3. Yes, in Victor 3. Can you tell us what that is?
This is work product for this case. This is the synchronized video timeline.
So that was your final product?
Yes, that's correct.
And then do you recall when you prepared that and returned that or offered that for pickup to me?
I would refer to my report.
Sure.
So that would be March 13th of 2019.
If you could tell us just a few of the points that were important here that you synchronized. I don't think I'm going to go through and stop and play the video here, but I'd like you to point out to the jury at what points there was something to synchronize that made you confident in your work here.
Yes, again, if I may refer to my report.
And you're referring to State's Exhibit E, is that 4?
E4, yes.
Okay.
So the points are referenced via the video timestamp, the timestamp that's visible on the surveillance video. At 11:49:06, there's a movement of the gurney. That's the wheels on the ground. Actually, the first 4 synchronization points are from the gurney and the movement on the ground. 11:49:08. 11:50 and 0 seconds, and 11:50 and 2 seconds. Each of those points as the gurney hits the ground or moves. Then at 11, then went back through to verify, and at 11:36:50, we have a vehicle door opening. There's also a change in ambient noise, so you can see the door open, but you can also hear the outside now. I was told the recording device was in the vehicle. Now the door's open, and you can hear the outside as well. At 11:38:09, you can see an individual sliding and falling to the ground near the door, and that is, you can hear that as well. And at 11:40:29, there's a shadow you can hear a vehicle door close. I believe it's a different vehicle and it's close to the top of the screen, but you can see the shadow of the door as it closes. So those were the main sync points that I used for this case.
So you said you can hear them. In addition to hearing them, are you also watching and looking at sound waves or other visual information to confirm that?
Yes, that's correct. You can also see the event in the sound, in the actual waveform of the audio.
And that's using the software you have?
Yes, that's correct. In this case, it's Adobe Premiere.
And has any other expert, anyone on behalf of the defense contacted you to discuss your work in this case?
Objection, Your Honor.
Sustained.
If another expert wanted to talk to you about your work, do you talk to them freely?
Yes.
Would you have talked to anybody about your work in this case?
Yes, I would if it was requested.
Thank you. Nothing further. Do you need the exhibits?
Any questions, examination?
Yes, may I proceed, Your Honor?
Thank you.
Good morning, Mr. Lewis.
Good morning.
We've got to chat before, correct?
Yes, that's correct.
Good to see you again. My name is Mark Collins, along with my partner, Caitlin Stevens. We represent Mr. Mitchell. You intrigued me earlier when you talked about some of your credentials, undergrad for animation.
Yes,
What type of animation did you get to do?
both 3D and traditional hand drawing animation.
You ready to do some Marvel animation or anything like that, or?
I'm sorry, which?
Did you do any Marvel animation or anything for the current movies and stuff?
No.
Was that your topic at the time, to learn about animation in undergrad?
It was, yes.
Okay, all right. Thank you. So you mentioned on direct and that all you're doing with the video is you're trying to enhance a specific area.
That was the initial request, yes.
And you're just trying to make it bigger so it's easier to see up on the screen.
Yes, that's correct.
But when making it bigger, that doesn't mean that you're bringing out any details.
Yes, that's correct.
It doesn't mean that you're clarifying things any bit, correct?
Not with the enlargement, no.
Right. So it's a simple thing to say, hey, I'm going to give you an exhibit that, in this situation, the incident happens way down in the video, correct?
Yes, that's correct.
And you make an enlarged area so that you can see it up closer, basically.
Yes, that's correct.
Okay. And I think when we talked before, you were very clear that you couldn't see any specific movements from the enlargements.
You can see movement in general,
Right.
but it's low quality video.
And no specifics. You couldn't see specifics, is what you...
I could not perceive specifics, no.
Okay. And you're trained to do that. I mean, you're looking at the videos, you're looking for things, correct?
Yes, that's correct.
And you couldn't see any specific details.
No, I could not.
Okay. And you mentioned that it was a low-quality video, correct?
Yes, that's correct.
So in this situation, we have two different sources. One source of video, right?
Yes,
One source of audio.
yes,
Okay. And with video, sometimes you can have video that's good quality,
yes, absolutely.
some with poor quality.
Correct.
Depends on the device, depends on how expensive it is, that types of stuff.
Yes, absolutely.
Same thing with the audio. You can have audio that has good quality, audio that has bad quality.
That's correct.
And and again, you know, I'm not too bright on this. With regards to the frames per minute of the video,
Yes.
so in theory, 15 frames per minute is not going to be as good as quality as 30 frames per minute.
As far as motion accuracy goes, higher frame rate is better. Yes.
Is there higher frame rate than 30?
Yes, there can be.
What does the frame rate go up to?
It can go as high as you want, as high as the camera can handle. You can have high-speed cameras that are thousands of frames per second.
Okay.
So standard video, 30 to 60 frames usually.
So the more standard is 30 to 60, and this was 15.
That's correct.
Okay. And same with the audio, correct? You can
That's
have different levels of audio that is picked up.
That is correct.
Okay. And you, I believe in your background and some of your training, you're also trained, well, let me put it this way. I'm sorry, Mr. Lewis. Devices pick up sound waves a certain way, correct?
Yes.
Okay. And a device may pick something up, but the human ear may not be able to pick that up, correct?
Yes, that's correct.
And that happens, and it's reasonable that that happens, correct?
Yes, that's reasonable.
Okay. And the way the ear is designed, the ear can receive trauma to it, correct?
Yes, that's correct.
And that can affect what allows an ear, what allows someone to hear, correct?
Yes, that's correct.
And if there was a trauma to the ear or a gunshot right near the ear, that, based on the sound waves and the physics and everything of that nature, that would have an impact on an ear, correct?
I mean, I'm not an expert in that field, but I understand what you're saying, yes.
So the way, I mean, Ms. Pritchard mentioned sound waves that you listen to try to identify things, correct?
Yes.
The sound of something can have a trauma on the human ear, correct?
Yes.
Okay. And so that can be an indication of why an ear might not hear something, correct?
As I understand it, yes.
Okay. And I think you told Ms. Pritchard on direct that you can't give an exact percentage of if it's synced up. You synced it up the best you could.
Yes, and it's very close. Yes,
Okay.
it's synchronized.
And you're satisfied with that?
Yes.
You took a source of video and a source of audio. And these points that you sync up, those sync points, those were sounds of objects creating sound, right?
Yes, that's correct.
Okay. So you use objects that create sound in order to sync it up?
That's correct, yes.
Okay. Nice to see you again, Mr. Loomis. Appreciate you being here today.
Any redirect?
Just one quick clarification. Mr. Lewis, I think perhaps Mr. Collins just misspoke, but he was talking about, he kept saying frames per minute. Your testimony was frames per second?
Frames per second, that's correct, yes.
All right,
Frames per second. I apologize.
all right, Mr. Loomis, you can step down. Just leave everything there.
Councilwoman Approach?
I've got it.
Everyone can have a seat. Any further witnesses on behalf of the state of Ohio?
Yes, Judge, I'd like to call Joshua Durst, please.
Come around here. I want you to put that yellow tape. Raise your right hand. Do you solemnly swear affirm under penalty of perjury your testimony in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat. Pull yourself up close to the microphone. You may inquire.
Thank you, Judge. Good morning.
Morning.
Can you tell this jury who you are and what you do for a living?
Yes, my name's Joshua Durst. I'm a special agent supervisor for the Southern District Crime Scene Unit. I work for the Ohio Bureau of Criminal Investigation.
And where are you based?
Our headquarters is based in London, Ohio.
Is that where you work from?
Primarily, yes.
And what is it on a general basis that you do?
I supervise the crime scene unit. We're a group of 8 individuals who assist local law enforcement at their request to come and process major crime scenes.
Okay. And in this particular case, was the request from my office to help?
One of the requests was yes.
Okay. What other requests were there?
In this case specifically, we had received a request from the Columbus Division of Police to look at the Mitsubishi Galant that was involved in this case. Subsequently, we also received a request from the Franklin County Prosecutor's Office.
Okay. And what happened as a result of the first request?
Myself and the supervisor at the time were requested to look at the vehicle specifically in regard to bloodstain pattern analysis and shooting incident reconstruction. They wanted us to look at the vehicle and assess it to see if there was anything related to those 2 fields of crime scene investigation that we could conduct on the vehicle.
Okay. And did you look at the car?
We did, yes.
And what was the result of that?
After we looked at the vehicle, it was agreed upon that because the Columbus Division of Police had already processed the vehicle, that can create some limitations for us as far as what we can do with those 2 types of analysis. As well as the circumstances of the case, we didn't feel that it would lead to any new information or different information in the case. So because it had already been processed and those 2 areas weren't really applicable in this situation, we declined the request at that time.
Do you recall when that was?
I believe that was in September of 2018.
And when did this second request from my office come?
I think about a month later in October of 2018, we received somewhat of a different request from your office.
And what was that?
I was asked to look at the case from a physical evidence standpoint, just to look at the case in its totality and look at the evidence that was collected and see if I felt that there was any additional testing or any additional examinations solely from a physical evidence standpoint that should be performed.
And did you believe you could do that?
There was a few things, after reviewing the case, there was a few things I wanted to look at in regard to the vehicle and some clothing.
Okay. And did that review include identifying bullet holes?
Yes, I searched the car for bullet holes, however, they had been previously identified by the Columbus Division of Police.
What about flight trajectories?
Again, the Columbus Division of Police had already looked at some trajectories of those bullets within the vehicle. During my analysis, I was able to use what's called a 3D laser scanner, and it creates a 3D rendering of the vehicle. The analysis wasn't different. It was just a different way to document those flight paths.
Okay. And at the time, had you reviewed any video or anything like that?
I don't believe so, no.
And what is it in your past that gives you the experience or the education to be able to do these kind of analysis?
So I've been in law enforcement for a little over 25 years. I've been a full-time crime scene investigator since 2010. I'm a graduate of the National Forensic Academy. I hold some independent certifications, one being a certified bloodstain pattern analyst, as well as a crime scene analyst. Just through the training, I have about 1,500 hours of additional training beyond what's required to be a police officer in Ohio, and over about 900 hours of that's specifically related to crime scene investigation.
Okay. And in this case, I think you indicated you were just checking for forensic evidence.
That's correct.
Okay. Were you tasked or capable of doing anything as relating to attitudes, motivations, or anything like that for the people in that car?
No.
Were you asked to make a judgment on whether or not what happened in that car was reasonable or not?
No, I was not.
Did you prepare a report for us based upon the investigation that you did?
Yes.
Judge, may I approach the witness?
Okay.
I'll show you what's been marked State's Exhibit 89. Can you tell us what that is?
Okay, so this is a copy of the letter that I drafted upon the completion of my analysis to the Columbus Division of Police as well as the prosecutor's office. Attached to that is a copy of my investigative report.
You have a copy separate from that with you here?
Yes. Yep.
Take that back then.
Sure.
When you looked at this car, when did you look at the car?
I believe I examined, can I refer to my report on that? November of 2018, so about a month after the request.
Okay. This jury has seen that car just this week out at the impound lot outside. Would it be fair to say that that car is probably in a different condition now than it was in 2018?
It's quite possible after 5 years, yes.
All right, I want to go through some of these. Did you take photographs?
I did.
All right, I want to go through some of these. I've got what's been marked State's Exhibit D1 through 68. And I want to show you, I want to produce some of them. Have you reviewed these photos before?
In the past, yes.
And are they fair and accurate representations of what you saw and did during your investigation back in October of 2018?
Yes.
I'm going to show you what's been marked as State's Exhibit D1.
Want the lights out?
Yes, please. What are we looking at here?
I wanted to look at some of the clothing of Mr. Mitchell and Ms. Castleberry. So this was the packaged evidence that was located at the evidence center at the Columbus Division of Police. I believe this container contains some of the clothing.
Is there a laser pointer up there? Yeah. So if you need to, you can use that. to show you what's been marked as State's Exhibit 6. What is this?
This was a knife contained in that box. I believe it was collected from Mr. Mitchell on the day of the incident.
Are you aware that there were 2 knives involved in this scenario?
Yes.
Okay, and does this appear to be the knife that was not used by Ms. Castleberry?
This was the knife that was in the contents of his property. Yes, yes.
Okay. And we see looks like a ruler. What do we got here?
This is just called an ABFO scale. It's a scale for reference. If there's ever a question about length or size of something, we throw those in our photographs so we can reference it later.
Okay. I'm going to show you what's been marked State's Exhibit 11. What is that?
This is Mr. Mitchell's underwear that was in the box.
State's Exhibit 13.
This would be a shirt that was collected from him, and it was in the box.
State's Exhibit 23.
The boots he was wearing at the time.
State's Exhibit 35.
The jeans that were collected from him.
This is on Mr. Mitchell's clothing.
Yes, sir.
Okay, I want to show you what's been marked as State's Exhibit 46. You recall what this is?
Within the box that contained Miss Castleberry's clothing, these were the sandals that were within the box.
This is a different box than the one that...
Correct, different box.
Okay.
Yes.
State's Exhibit 50.
This would be a portion of the fabric that was cut out from her dress. It was just like that when I opened the box, so I'm not sure how it was cut. I presume it was from medical intervention, but
And is that consistent with clothing that's been subject to medical intervention?
absolutely, yes.
And State's Exhibit 51.
This is a close-up photograph. It's difficult to see on that photo, but right here is what I believe to be a bullet hole in the dress, or that material.
And there appears to be staining on this. Can you tell what that is?
Believe it's blood.
And what you know of this case, does that make sense?
That would be consistent, yes.
State's Exhibit 60.
This is the dress that was within the box. These are just smaller adhesive placards like that L scale, except these are stickers, and we can use them to mark things and reference sizing, and that's the white pieces on the front.
I'll show you a close-up of one. State's Exhibit 61. Is that what we're looking at?
That is, yes.
And that's just to measure the bullet hole?
Correct.
And then State's Exhibit 68. I'm sorry, these are all D. Carla, I apologize. D. This is the D series. I may not have been saying the D part.
This, again, just another photograph of the dress. I believe this is the back side of the dress. And I just introduced 2 scales. Number 3 would be the bullet hole.
And what, if anything, were you able to determine from this clothing?
There was 2 suspected bullet holes in the front and one up and one in the rear. Outside of that, there was nothing inconsistent or I guess surprising to me about that made sense with what I knew about the incident.
Did you also take photographs of the Mitsubishi Galant?
Yes.
I have what's been marked as State's Exhibit C1 through 47. Have you gone through these before?
In the past, yes, I have.
Okay. And are these pictures accurate, fair and accurate representations of what you saw when you took the pictures of this Galant back in 2018?
Yes,
Will you let me know if something isn't?
yes.
Okay. I'm going to show you what's been marked as State's Exhibit 2. What
This is the Mitsubishi Galant. This is the driver's side of the vehicle.
And where is this located?
This is what they refer to as the barn or the impound garage at the Columbus Division of Police.
The same, at their impound lot down there on Hall Road?
Yes.
I'm going to show you what's been marked as State's Exhibit 4.
This is the photograph of the interior, the front interior of the vehicle. I would be standing on the passenger door, or the passenger opening, taking a photograph toward the driver's side.
And at this point, if I'm not mistaken, Columbus Police has already processed this car.
Yes,
So if they did any work with dowels and pictures and evidence, they've already done that by the time you get to this point. Is that correct?
yes.
Okay. There appears to be in State's Exhibit C4 here, if you look at the driver's seat, maybe some deformity. Can you tell what
Yes.
I'm looking at?
This right here?
No, I'm sorry, down on the seat.
Oh, this.
Yeah.
Okay.
Do you know what that is?
I don't recall. There may have been a section cut out of the seat, which is normal for if a sample of something's being collected. But I did not cut it out, though.
Okay. Look at C7, does that help you?
Yes, that's what it is.
That's been cut out
Yes.
prior
so.
prior to you getting it.
Correct.
Okay. But that's consistent with somebody forensically cutting a piece of fabric out.
Yes.
Let me show you what's been marked as State's Exhibit C10. You recognize that?
Yes. This is a bullet hole in the headliner. It would be directly above the rear passenger side seat.
C15.
This is a photograph of the rear wheel on the driver's side. There was a bullet recovered by the Columbus Division of Police out of this tire. So to access that bullet, they would have had to cut the tire open to get that.
State's Exhibit C24. Recognize that?
Yes. This is a bullet hole that's in the back seat. There's an armrest in between the driver and the passenger side seats. So there's a flip up armrest, and there was a bullet hole in the top portion of that armrest.
C30.
So this is the rear seat on the driver's side. There is a bullet hole here where you can see the scale. There was a bullet hole there in the seat.
And I believe it's close up here, C31.
Yes, same bullet hole.
And C32.
This is the wheel well of the same tire that you saw cut open. So this is the rear driver's side wheel well, and this is the bullet hole where it exited through and then went into the tire.
And then I want to get to C34. What are we looking at here?
These are trajectory rods that are placed in all of these bullet holes, and that helps us visualize and understand the trajectory of that bullet after it was left the gun.
Okay. And what's our vantage point here?
So at this point, I'm standing on the doorway opening on the rear driver's side of the vehicle.
So this would be right next to that flat tire?
Yes, it would.
And then in C35, what's our vantage point?
This would be from the rear passenger side of the vehicle.
And are those the same three trajectory rods that we saw in the last photograph?
I believe I'd like to go back to the other one, because there's one in the front driver's seat, and I'm not sure
Okay,
if you could see.
here's C-34.
Okay. So here we can see the trajectory rod in the front driver's seat, and then the two in the back seat. I think the next photograph you see another one.
Right.
So you can see this better. There's a fourth trajectory, and that's going through the headliner.
And then C-36.
This photograph was taken from the front passenger side, and this is a photograph of the trajectory through the front driver's seat.
As part of your investigation and search for any further forensic evidence, did you take any additional images of this car?
Well, there was a series of photographs, and then we have the 3D laser scan, which there are images of that.
I'm sorry?
There are images or screenshots of that product.
Can you tell us what you mean when you say 3D laser scan?
So we have devices, again, 3D laser scanning. It takes hundreds of thousands of measurements every second. So we use it a lot for just documenting crime scenes, dimensions at crime scenes. We don't have to use tape measures anymore. So we can create a 3D rendering of a crime scene or a vehicle, and it's very helpful, especially when we're doing some type of shooting reconstruction or just trying to illustrate shot trajectories. So in this case, I use the 3D laser scanner, and it helps further visualize these trajectories.
Okay. I would like to show you what's been marked as State's Exhibit A1.
Lights?
Thank you. Can you tell us what we're looking at here in A1?
Yes, this is an image from the passenger side looking towards the driver's side of the vehicle, and it's showing. This is actually showing the trajectory or the flight path of the projectile that went through and exited, perforated the headliner there above the rear passenger seat.
This looks a lot like an X-ray.
This is switched to what we call grayscale mode. So although it does look like a photograph, it's not. Everything you see up there is a measured point. So as it collects literally millions of points, it plots a dot. When those are all put together, with the setting I have it on, yes, it looks somewhat like an X-ray. And I can change some settings to make it look transparent so we can visualize all the way through the car. But it's not an X-ray.
Okay. And were these originally taken, could you put them in color as well?
Yes.
Okay. But does this make it easier to distinguish features?
Yes.
I'm going to show A2. What are we looking at?
So this, again, this is flight path 2. This is the shot that went out the roof. And every trajectory will have essentially 3 components. Directionality, which means that they go from inside to outside or from outside to inside. And then there's 2 angular components. Was a bullet traveling up or was it traveling down? So that's the vertical component that we talk about. And then it's directionality. So if you think of a compass, is it going right to left to right? Sometimes we can refer to direct, like angular direction, 37 degrees relative to something. Didn't get into that level of detail as far as angular data, but directionality is important. And referencing all of this will be as you were sitting in the front seat facing forward. So as we talk about trajectories, if it's left to right, it's from driver's side to passenger side. So this just illustrates that horizontal component. You can see that the trajectory is from left to right.
And if we're looking at A3,
so this is flight path 1. This is there was a shot that went through the driver's seat, just to the right of the headrest, and it's going significantly. Actually, I'm not.
I tell you what.
That might not be flight path 1.
Let me ask you this: these I call them photographs. These laser images.
Yes.
Did you incorporate those into your report?
I did. Yes.
Okay, so maybe why don't we do that? Why don't we go to your report? And go through these flight paths.
Okay.
All right, I'm going to go to page 3 of 11 on your report, and we'll talk about what you have labeled flight path 1. And before we get too far into this, you've labeled these, I believe, 1, 2, 3, and 4,
Yes.
right?
Yes.
We've heard testimony there were 6 shots fired. Why aren't there 6 of these?
This is based solely upon bullet holes and ballistic damage to the vehicle. So if we don't have bullet holes in material of the car, I'm not talking about those trajectories. I can't talk about those
So
trajectories.
if 2 of the bullets fired remained inside of Donna Castleberry, you would have no way of analyzing those?
If they struck her and didn't strike anything in the car previous to striking her, yes, I wouldn't be able to talk about that trajectory.
And also, you've numbered them 1 through 4. Is that in any way indicative of the order in which they were shot?
No,
Do you have any idea the order in which these bullets were shot?
not in this case, no.
All right, let's look at flight path 1. And what are we seeing here on these 2 images?
Okay, so this is flight path 1. This would be the trajectory of the bullet, again, that traveled downward through the front driver's seat. So it is traveling, again, from left to right, significantly downward.
And these 2 images are both the same, you're tracking the same bullet.
Correct, same trajectory, but the top photograph allows you to see the vertical component, so you can see it's going down very, very sharply. The bottom image is just a top-down perspective, so you can see, is it going left to right? And you can see in this one, right here, it's going slightly left to right.
Did you find any evidence in the vehicle itself of this, from the firearm of this trajectory? Any soot, any stippling, or whatever we want to call that?
Yes. There was the seat material right there where the entrance hole was in the seat contained what we call suet and vaporous lead, and that was something that I cut out and collected just to have it. I don't think it was tested at any point, but just to preserve that. And typically we encounter that when the muzzle of the weapon is close to the target surface. So it's just a factor of the gun being shot and the gases being expelled out of the barrel. If that barrel's close to the seat, we'll see that. We'll see that vaporous lead and that kind of powder burn look.
You know how close?
Without doing experimentation, we can't really talk about distances, but it's close. I would anticipate, a foot to foot and a half or closer. I mean, it's not a long distance off. You wouldn't see it from the distance of me and you.
Okay. And when we're looking at this arrow, let's look at the top photograph. You start the arrow at sort of the point of entry of that armrest or that headrest, right?
Yes.
Do you know exactly where that firearm was when it was fired?
Well, in this flight path, this situation, I know it has to be forward of that seat because we see the suet and the vaporous lead on the seat. So I know it has to be before that. In certain shots, no, we don't know. We don't have that powder burn. We don't know. So yes, the muzzle could be anywhere along that line when the bullet was fired from the gun.
But in this case, does it have to be before the headrest?
Correct, it does.
So is there any evidence that it came through the top of the car?
No. All of the shots, flight paths 1 through 4, all happened within the vehicle traveling outward.
So is it fair to say that this firearm had to be between that armrest on an angle with that line between the armrest and the hood or the top of that car?
The headrest, not the armrest.
sorry,
The head,
the headrest,
yes.
yeah.
So between the headrest, yes, and the headliner, it has to be somewhere in there.
On that line.
Correct.
Okay. And do you make any assertions or statements about how that gun was being held?
No.
So do you have any idea of whether it could have been this or it could have been this?
Correct. Yes,
There's no way to tell that kind of stuff.
correct. Not in this situation, no, not in this case.
And for the record, I was using my left hand across my body and my right hand over the top of my body. Anything else on flight path 1?
No, I don't believe so.
Okay, let's go to flight path 2. Tell us what we got here.
Okay, so this is, if you can recall, the bullet hole that was in the headliner in the back seat above the passenger side. This is flight path number 2. So again, looking at the vertical and horizontal components, this bullet traveled upward and from left to right, and then it exited through the roof and was gone. It was not recovered.
So what does this tell us about the location of the firearm when it was fired?
So in this situation, it has to be somewhere between that front driver's seat area and where it entered that headliner. It has to be somewhere in there.
And did you find any soot or vaporous lead in that one?
No, not on the headliner, no.
Flight path 3.
So flight path 3, if you recall, was the rear armrest in the back seat. There was a hole there. That projectile travels through into the trunk and is later recovered in a container by Columbus police. The trajectory of this, again, is slightly downward, as you can see in the upper image, and it's traveling from left to right in the lower image.
And what can you tell us, if anything, about the location of that firearm when this bullet was fired?
That's going to have to happen somewhere between that driver's seat and that back armrest, because if you extend the line any further, the front seat's in the way. So the muzzle of the weapon had to be somewhat back around, I think.
So behind the headrest?
Correct.
And that's because you don't see any defects in the headrest itself to indicate that it went through?
Yes, that's correct.
Do you see any soot or vaporous lead associated with this firearm?
No.
This bullet?
No.
And you believe this to be the one that was located in the trunk?
Yes.
Do you have any way to know whether or not this bullet actually struck Donna Castleberry?
I don't know.
Anything else about flight path 3?
I don't believe so.
We can always go back and pick up something if you think. Flight path 4? Nope.
So this is the trajectory, the bullet that was recovered in that tire, in the rear tire. This travels through the seat, downward, through that back seat. It exits the wheel well, then re-enters the tire, and then they ultimately find the bullet in the tire. So in the upper image, you can see that trajectory is significantly downward, and this is actually traveling from the right to the left.
And can you make any determinations about the location of this firearm when it fired this bullet?
Again, we can extend that. If we look at the lower image, we can extend that line. But again, it somewhat terminates out in the upper image towards the headliner. So it can only go so far up and so far back. So I stopped those lines where essentially the limitations are. So, but it could be anywhere along that line.
Okay. And again, any soot or vaporous lead associated with this?
No.
Did you find any evidence of any bullet trajectories that went from back to front of this vehicle?
No.
We mentioned earlier that, now Courtney. We mentioned earlier that you had looked at Mr. Mitchell's clothing, photographed it, and I think you said that didn't change anything in your analysis, is that correct?
Correct.
And you looked at Donna Castleberry's clothing, photographed it. Was there any change in the analysis from that?
No.
Did you eventually watch the video?
I did, yes.
Okay. Was there any change in your analysis from watching the video?
No.
So what you see here, what you see in that video is still consistent with the forensic analysis you just told us about?
Yes.
Did you have an opportunity to look at Mr. Mitchell's duty pistol?
Yes.
What can you tell us about that?
So while reviewing photographs, I noticed there was when the pistol was originally collected from him by the Columbus Division of Police, there was a malfunction in the firearm. As I looked a little closer, it was a malfunction I was not familiar with. Do you want me to explain? Okay, so there was a cartridge casing, which is what's ejected from the gun after the gun's discharged. There's a cartridge casing stuck within the opening of the action of the gun. That can happen from time to time for a variety of reasons. This was a little different because as the gun's fired, a casing is ejected from the gun. In that same process, it takes ammunition from the magazine, puts a cartridge into the chamber so that it can be fired again. That's why it's called a semi-automatic firearm. So in this malfunction, it didn't fully eject the casing, but it also started the process of taking a cartridge out of the magazine and trying to get it into the chamber so it can fire another shot. Well, it didn't happen. That cartridge didn't fully make it into the chamber, and the casing didn't make it out of the gun either. Typically, we don't find both of those happening at the same time. I can't explain to this day why it happened or how it happened. I relied on some people in our firearms laboratory. They took a look at these photographs. I actually talked to some of our firearms instructors over our police academy, showed them the photographs. None of us can figure out how or why. What was important to me was, could this have been staged somehow or purposely done this way? And the consensus was no. It's extremely unlikely that you could make this happen.
So it just happened?
It's a phenomenon I can't explain, but...
Well, let me ask you this. If, in that condition, would it be possible to fire that gun again?
No, the gun was inoperable the way it was.
And so is there any way to tell, we know 6 shots were fired, is there any way to tell how many times the trigger may or may not have been pulled after that jam?
No.
Special Agent Durst, you've had a lot of law enforcement experience. Have you ever dealt with sting operations or prostitutes or anything like that?
No, I have not.
So you're not attempting or qualified to talk about any of those kind of issues here?
No.
Okay. You've mentioned the video. I think you've already said there's nothing inconsistent with that, but you don't have any idea in what order these bullets were fired. Is that correct?
It's correct.
And did you review Mr. Mitchell's written statement?
I did.
Okay, and at some point here, I think in the front of your report, you write that you have found no discrepancies or conflicts between items of physical evidence and the statement of Detective Mitchell regarding what occurred in the incident. What does that mean?
Again, looking at all of the evidence, all the physical evidence, and reading his statement, there was nothing that I felt was unexplored. There was nothing inconsistent with physical evidence weighed against what he said happened. So we weren't looking for additional evidence. We weren't looking to do any additional processing necessarily based upon something that he may have said.
So in other words, he didn't say something like, I fired 10 times.
Correct.
And so then you would be looking for more bullet holes, right?
Yes.
Okay. And are you making any comment whatsoever with this statement about the reasonableness or the why of these shots?
No.
Just that there were shots forensically that match up with what he said?
Correct.
That's all I have, Judge. Thank you.
Any cross-examination?
May I proceed, Your Honor?
May?
Thank you very much. Good morning, Agent Durst.
Morning. How are you?
We've met before, correct?
We have, yes.
Thank you for being here today. My name is Mark Collins. As you know, along with my partner, Ms. Stevens, we represent Andy Mitchell. Appreciate you being here today.
Sure.
I want to start off just with some basic concepts, okay?
Okay.
When you get to a scene, for most of your career, your job is to gather evidence and analyze it, correct?
Yes.
Okay. And when you get to the scene, obviously you're not there when it happens.
Correct.
So you have no idea how those potential items of evidentiary value got to the place where they're at, correct?
Correct.
None whatsoever, right?
I mean, there's times we can do, that's part of the investigation, that's the goal.
Absolutely. So it's a poorly worded question, I apologize. When you get to a scene and there's shell casings in the area, you start from a premise with a shell casing that they're ejected from the right, correct?
I don't go that far either, because there's a lot of left-handed, or left side ejection, but they were definitely ejected from, unless somebody just threw them out, yeah, they were ejected from a firearm.
So you start from premise, geez, if all of the shell casings over here and the individuals who shot was right-handed, they probably were to the left side of those shell casings.
No.
Okay.
They're,
They could be moved before you get there.
yes,
They could be, the wind could have moved them, weather could have moved them, something like that, correct?
correct.
So you're doing the best you can when you get there to try to say, hey, here's the physical evidence we have, but you have no idea how it actually got there during the situation. Is that a fair statement?
No, I think we can determine how things got there. It's not, they just didn't fall out of the sky. We know, I mean, casings of the scene, either somebody threw them there or they were ejected from a firearm.
Correct, but you can't say how they ended up in that specific spot, or where somebody was in relation to that.
Correct.
Okay.
Yeah.
Let's take another example. Mr. Cable talked to you about the car that you examined, right?
Yeah.
And you said, well, it's probably in a different condition than it was 5 years ago, right? When you examined it,
Sure.
right? The dimensions haven't changed, correct?
Correct.
The size of the car hasn't changed, correct?
Right.
The compact nature of it on the inside hasn't changed, correct?
Correct.
You're talking about the way it looks from the outside or something like that. The physical structure and the compact nature has not changed, correct?
Correct.
So those are things that you can analyze and say, yeah, that's the same thing versus it doesn't appear to be the same as it looked 5 years ago, right, when you examined it?
Yes.
Okay. And when you examined, you gathered a bunch of information in this case, correct?
I'm sorry?
You gathered a bunch of information in your analysis for this case, correct?
Yes.
Okay. And if you could go to the back of your sources reviewed in your report, please.
Okay. Sure.
Let me know when you get there.
Mhm.
So in the sources reviewed, on the, sorry, Courtney. Sure. So in that section, Agent Durst, you have 32 different items that you reviewed, correct?
Yes.
Medical records of Mr. Mitchell, correct?
Yes.
Interviews of people, correct?
Yes.
Interviews of people on the scene, correct?
You may want to enlarge it.
Oh. Did you do this on purpose, Tom? No, that's okay. You can turn the lights on. On that list, you include 32 different items, correct?
Yes.
As much information as possible, correct?
Yes.
And there's a subsequent page to that, correct?
Yep.
Another 20 additional items on that, correct?
Yes.
Okay, so you had all of those items that you reviewed, and you had my client's written statement, correct?
Yes.
You had the tape recording, correct?
Yes.
Okay, so all of that you had prior to penning the letter of January 23rd, 2019, correct?
Yes.
And that's on page 1, right?
Yes. You mean the letter that I sent to Deputy Chief Becker?
That's correct.
Yeah. Yes.
So if for the ladies and gentlemen of the jury, could you read the paragraph that says, I have reviewed all the materials to them?
Sure. I have reviewed all materials provided to me by the Columbus Division of Police, to include investigative reports, photographs, laboratory results, autopsy reports, statements, audio recordings, and video recordings. I have found no discrepancies or conflicts between items of physical evidence and the statement of Detective Mitchell regarding what occurred during the incident.
Your job is to analyze physical evidence, correct?
Yes.
Your job is to then compare it to the written statement, correct?
Yes.
And based on his written statement that was given, you have no conflicts that the way the physical evidence is, the way what you examined conflicts with my client's statement, correct?
Correct.
Now, you got involved, I think, late October of 18, correct?
Yes, sir.
Met with prosecutors, met with many individuals, because you did a thorough job, correct?
Yes.
You pride yourself on doing a thorough job, correct?
Yes.
And again, you indicated that there is no way to tell the order of the shots.
That's correct.
Okay. And on the flight paths that you talk about, I think what you were trying to, correct me if I'm wrong, if I understand this right, if a flight path is, example of my pen, we'll put it up here, right? Okay? That flight path, if the analysis is from this side, what would that flight path be?
From right to left and downward.
Right, from right to left and downward. But what you're saying is you can't tell, ladies and gentlemen of the jury, if the gun was here, 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 or here. Correct?
In some situations, that's correct. Again, with the vaporous lead on the seat,
Sure.
we can make some assumptions about the distance. But generally speaking, correct. I cannot along the flight path.
And some of the flight paths in there probably occurred when the gun was in the back seat, correct? It's possible.
It's possible.
Okay. And you mentioned the soot and stuff on the seat, correct?
Mm-hmm. Yeah.
That means that the gun was between 0 and 16 or 18 inches from that seat.
Approximately, that's what I would anticipate. Yes.
However, when it goes through the seat and then out, you have no idea where that bullet goes from there, correct?
Unless there's another ballistic event along that flight path that we can connect to that trajectory.
Was there a ballistic, another ballistic event that you could compare that to? Did you find a projectile from that?
Which flight path are we referring to?
Flight path through the seat that you have going down to the left.
Are we talking about the one that goes? There's two seats. We got a seat in the front seat, the front driver's seat.
The headrest.
Okay. Yes, it's going downward, and no, there was no bullet recovered with that. There was no third point. There was no.
So even though you put the dowel through and you thought it was going this way, once something goes through an object, tell the ladies and gentlemen of the jury what happens to a bullet that goes through an object and it tumbles.
If a bullet tumbles, if it becomes destabilized in its flight, yes, it can curve left, it can curve right, it can deflect.
But your analysis, you believe that it should have gone this way, but you found no projectile to confirm that.
I found no projectile. I had no evidence to suggest that bullet was in destabilized flight, though.
Oh, but there was no bullet strike on the lower left side, correct?
Correct.
There was no projectile found there, correct?
That's correct.
So that doesn't really make any sense, right? You would think that the bullet or projectile strike should be down there if you're putting the dowel like that, correct?
Yes, unless it's one of the projectiles recovered from the body of Ms. Castleberry.
Okay. So in terms of, I think you told Mr. Cable on direct that just like you have no idea where the actual, you have an idea, there's a path that the gun must have been pointed, correct?
Yes.
But you have no idea if a person's standing here with the gun, right, on this side of it? The person could be standing on this side, right?
Yes, that's correct.
The person could be standing right there in the middle of it.
Yes.
Okay, and the same could be said of the target. You have no idea where the target is at that point in time,
That's correct.
based on the flight path record,
Right.
correct? Okay. And I think one of the flight paths, you never found a projectile to connect to it. That's one we were just talking about, right?
The one through the roof, we didn't find a projectile either.
Okay, so two of them, right?
Okay.
And I believe you testified that that malfunction was new to you, but you believed it was not intentional.
That's correct, yes.
Pretty difficult to intentionally do that with what you reviewed in this case, correct?
Correct.
Okay. And is it fair to say with the flight paths that there was may I approach the witness? Okay. Just because I want to be consistent. I apologize. Your analysis was as though we were in the front seat, correct?
Yes.
Okay. So there's a flight path going this way, top down,
Yes.
left to right, right to left.
Right to left, yes.
Okay, so it's going this way.
Yep.
There's another one that's going this way. The
Yes,
opposite
yep,
direction.
yep,
There's another one that's kind of going kind of straight, right?
yes,
Okay, 3 different directions, correct?
yes.
Consistent with somebody moving or a target moving in 3 different directions? That could be reasonable, correct?
That's possible, yes.
Okay. It could be reasonable to infer that, correct?
The angle of the weapon is changing based upon the shot trajectories. What's causing that, I can't say.
But it's not unreasonable to believe that the person in the back might have been moving, correct?
That's true, yes.
You have one up in the roof, right?
Yes, yep,
That's another angle, correct?
yes.
Okay. May I have a moment, Your Honor? And I think you told Mr. Cable this, but all the shots were fired from inside the vehicle.
That is correct,
Okay. And have you had firearm training?
yes,
Okay. And when you have that training, you have the protective ears on, gear on, correct?
yes,
Okay. And that's because pretty loud when you're firing a firearm training, correct?
yes,
Okay. Have you ever had to fire a weapon inside a vehicle?
yes.
And how did that sound to your ears?
Like, we had ear protection on,
Okay.
but it's loud.
Loud. Could you hear much else after you fired inside a vehicle?
With ear protection on, I had no problem.
Okay.
I've never fired a weapon inside a vehicle without ear protection on.
Okay. And is it fair to say that that's a loud situation?
Yes,
And it's fair to say that you might not be able to hear something that's being said to you after that point in time, correct?
it's possible,
Okay. Reasonable, correct?
yes.
Okay. And again, based on your thorough review of everything, of the 50-some, I apologize, let me get this right, of the 52 items and all the different aspects, you indicated that you compared all of that to Mr. Mitchell's statement, and there were no discrepancy or conflicts between his written statement and the physical evidence, correct?
My analysis of the physical evidence, there was no discrepancies that I found to Mr. Mitchell's statement.
Compared to his written statement.
Yes.
Agent Durst, nice to see you again. Thank you very much.
Thank you, sir.
Any redirect?
Just briefly, Special Agent Durst, we're talking about no physical discrepancies with the physical evidence. Were you looking for other discrepancies in his testimony?
No,
So if he says the door wasn't open, but the video you saw showed it was open, is that of note for you, or are you just tracking bullet paths?
I'm just looking at the physical evidence.
And you would, if I'm not mistaken, you would not have had access to anything that happened after you received the stuff you did in November of 2018, is that correct?
Yes, that's, everything I've looked at is listed in the report.
So you would not have looked at the synced up video which matched audio and video?
Not at the time of my analysis, no.
Okay. And again, in analyzing this forensic evidence, can the forensic evidence in this case really, or most any case, tell you whether the person who fired these shots, which you've gone to lengths to track, can it tell you whether the person fired these shots in anger,
No,
in self-defense,
no,
justification?
no.
Okay, that's all I have. Thank you.
All right, you can step down.
Thank you, Your Honor.
Council want to approach?
Very carefully, we've got a couple cords.
Careful with the
You're gonna have
cords.
to go all the way around to get to the
All the way
witness.
around here, little maze.
You raise your right hand, you solemnly swear, affirm under penalty of perjury, your testimony in this case will be the truth, the whole truth, and nothing but the truth? I do.
Have a seat and pull yourself up close to the microphone. You may inquire.
Thank you, Your Honor. Good afternoon. Well settled there.
Good afternoon.
Would you please introduce yourself to the jury?
My name is Yuri Patrick. I'm a retired FBI agent, and I've worked over the last several years as a consultant and expert witness on police training matters and use of force matters.
All right. Mr. Patrick, you're from Virginia,
Yes,
right? And so we flew you out here as an expert witness, is that correct?
you did.
Compensated you for your time?
Yes,
Is that industry standard?
yes.
Would you tell the ladies and gentlemen of the jury a little bit about your background?
Well, I served 24 years in the FBI. Roughly 15 of that period, I was at the FBI Academy in Quantico as a full-time instructor in the firearms training unit, where I worked on tactics, firearms, both technical, new weapons specifications, new ammunition, as well as arrest and techniques, mechanics of arrest, and we worked in close conjunction with the legal department because we changed, during my time there, we changed FBI training over to a more judgmental based training curriculum. We wanted our agents, and it's transmitted, or also went into police training, to apply judgment to try to recognize situations and adjust accordingly. Prior to that, agents were qualified on the range, and that was the end of their training. So we kind of went to a 2-semester system, basic skills, and then how do you apply those skills in a practical sense relative to the job you're going to be doing. And I retired from the FBI in 1997. Had moved to Maine at that point, and in 1999 I was approached by Maine law enforcement, wanted me to do some instruction and provide some services to them through the Maine Criminal Justice Academy and the Maine State Attorney General's Office, which are the two primary training and certification authorities for the state of Maine. I did that for the next almost 20 years, traveling around the state, working at the academy, giving regional training to police departments, sheriff's offices around the state. At the same time, I began this expert witness consulting business in 1999, which took me around the country on a wide variety of cases in a wide variety of locations, dealing with police and use of force issues predominantly.
Let me approach, if I may, with State's Exhibit I-1. Could you tell us what that is?
This is my CV.
That outlines your training, your fields of expertise,
Yes.
accomplishments, things of that nature?
Yes, my employment history, areas of expertise, accomplishments, publications, instructional background, and some of the positions well, it's not so much position, but the activities I was engaged in with the state of Maine and surrounding areas.
All right. I want to ask you about your fields of expertise, and just a few. I don't want to get into too much detail. There's a lot of information here, but fields of expertise, deadly force.
Yes.
You've testified and trained officers in deadly force over the course of your
Yes. Yes.
20-something years?
Yes, starting with when I was still a full-time instructor at the FBI Academy, and then my second career with Maine law enforcement. It was the primary topic of instruction for the schools and regional seminars I would give to law enforcement around the state.
Would that be the same of the use of force judgmental training?
Yes, essentially
And there's a lot of various firearms trainings that you've listed as a field of expertise.
yes,
Over the whole course of your career, you've been trained others,
yes, yes.
and you have techniques and mechanics of arrest. Also an area of expertise for you?
Yes, that was primarily a basic level training for new agents and for basic level police trainees on how to make an arrest, how to make an approach, what tactical considerations you need to take into account, how to organize, how to control and subdue, if necessary, any resistance you might meet, how to try to plan ahead to prevent resistance, just the whole gamut of things that goes into planning and successfully executing an arrest.
While working for the FBI, did you also help shape policy and national standards?
I worked on firearms, ammunition. The ammunition test protocols that we developed are now industry standard for law enforcement throughout the country. I also worked hand in glove with the legal unit. My associate and co-author, John Hall, who was instrumental in rewriting the Department of Justice Uniform Deadly Force Policy, which is applicable to all federal law enforcement. And
Then on page 3, you note various publications and articles. I'm going to focus in on just one in particular. You wrote a book in, was it about 2005?
yes,
In Defense of Self and Others, Issues, Facts, and Fallacies.
yes.
Who was your co-author on that?
John Hall, John C. Hall. He's another agent. He was a lawyer, legal expert, and in fact was the Department of Justice go-to expert on constitutional law dealing with use of force and deadly force. Not just the FBI called upon him, but the DOJ did as well. And he and I were friends. We met at the academy. He was in the legal unit. I was in the firearms unit. And we would cross-train. We would, especially once we got into our practical applications and judgmental training courses, there would always be a firearms instructor and a legal instructor working with the students. So we could draw lessons from what they did. We used computer simulations and we used role players and a variety of techniques to try and put them into rapidly changing and dynamic situations without actually getting somebody hurt. And then John became the unit chief of the firearms training unit, and I was his assistant unit chief for a period of years. And then he went back to legal, and I went to Maine.
Okay. You have an instructional background. You did a lot of training out at the FBI of new agents, firearms training, things of that nature?
Yes. Plus police schools, regional police schools around the country. We would, a field office would sponsor a school and invite police departments throughout its territory to attend, and we would fly out and conduct the school. And then we did that maybe half a dozen times a year.
So you've trained officers all over the state?
Yes.
All over the country, I mean, I'm sorry.
Yes.
Thank you. Let's talk about your courtroom experience. As an FBI agent, just testifying for the government, I know you said you testified in over 200 federal criminal cases. Would that be in your capacity?
That might be on the high side, but over the course of 24 years, although when I was at the academy, I didn't do any testifying other than in contract disputes. And there was an FBI shooting where one agent killed another agent. Not to get into the details, but he was terminated, fired, and then was suing to be restored, and I was the government's expert witness to refute some of his allegations. But those were the only trials or courtroom cases I had during my time at Quantico. But before then and after then, I testified in a number of criminal cases.
And I note from your CV, you have testified in 31 states and in Puerto Rico. Is that accurate?
I've been retained in those
Okay.
states. I've not necessarily testified. I may have been depositions, may have been courtroom testimony. Overall, I've testified in 26 trials and roughly 30 depositions.
Okay. And what percentage of those are criminal versus civil, if you know?
The trials, there were 10 criminal trials, and that would be 16 civil.
When we're, just for the jury's benefit, when we're saying civil trials, do those civil trials still involve your expertise
Yes,
with regard to use of force?
civil trials involve somebody suing a police officer or a department, usually alleging excessive force or wrongful death, any number of things having to do with an officer's exercise of force.
So the analysis in your criminal and civil is still using essentially the same standards. Would that be accurate?
Well, I mean, the standards are established by the Supreme Court for which determines when and under what circumstance a police officer can use force. And those standards apply to every department, every officer across the country uniformly. There's no variation. And those are the only standards we've got.
And you said maybe about 10 of the cases went to trial and were criminal,
Yes.
right? And how many times of those 10 cases were you testifying on behalf of the officer?
8 of the 10.
And so there's been 2 times you've testified against an officer in your
Yes.
entire career?
Yes,
And is one of them this case?
it is.
So there's one other.
Yes.
You were part of a big case here in Ohio, State versus White, that involved use of force by an officer, right?
Yes.
Who did you testify for in that matter?
Officer White.
And you were retired. When did you quit taking cases as an expert?
I started slowing down about 2018, 2019. I still had some cases that hadn't wrapped up. I was going to honor those, but I wasn't planning to take any more cases by about 2019, any new ones.
And at some point, we reached out to you regarding this case. Were you taking new cases at that time?
No, I wasn't.
Yet here you are.
Here I am. Yeah, I think originally I was contacted to recommend an expert, someone to work with you, and then I was called by Chief Flynn, and I do not recall whether he was with the PD or the sheriff's office, and he was urging me to take this case, and another colleague, a man
I'm going to object to the hearsay of what these other people are saying.
I'll sustain that. You can ask your next question.
So I reached out to you asking if there was an expert since you were no longer taking cases, right?
Yes,
And what was it? We were just asking for an opinion, correct?
yes.
When you decided you were going to work with us, did my office tell you we were looking for any particular opinion?
Oh, no,
So we asked you to just make an independent judgment about this case. Is that correct?
yes.
Do you ever have situations where you give an opinion that maybe doesn't help one of the parties, I guess their theory or their case, and they don't ever use you any further beyond your opinion?
Yes, that happens happened relatively commonly.
You don't know anyone involved here in this case, correct?
I do not.
Let's discuss discuss the law and standards that apply when we're judging an officer's use of force. Tell the ladies and gentlemen of the jury what standards we use, the prevailing standards in case law.
There's 2 levels of force that police officers can use. deadly force, which is self-explanatory, and non-deadly force. And they're, both of those, any use of force is by definition by the Supreme Court a Fourth Amendment seizure matter, so they've established a standard by which any use of force is to be assessed as to whether it was justified or not. That standard is objective reasonableness, which means that those who are assessing or sitting in judgment of a use of force are to look at the circumstances of a use of force, are to look at the circumstances, the events, what the individual people did from an objective viewpoint, independently of subjective fears, such as I was in fear of my life or that type of, and make a determination whether the officer's use of force or perception of the need to use that force was reasonable under the circumstances. Now, for non-deadly force, the standards are essentially that an officer may use that degree of force reasonably necessary, but no more. It's capped. For deadly force, there are only two circumstances in which the court has established are the only circumstances in which deadly force is justified. One is to prevent an imminent risk of serious death or serious injury or death, and the second is to prevent the escape of a dangerous individual. The court defined a dangerous individual as someone who has inflicted or attempted to threaten to inflict serious injury, but most departments have pulled back from that and have a much more stringent policy regarding using deadly force for prevention of escape. In the first instance, though, protection of self and others, the officer perception that risk is imminent and deadly force is necessary to terminate that risk is what triggers or I don't say triggers, but is what those assessing it need to look at. Hopefully corroborating that perception with realities of the circumstances, forensic evidence, the realities of dynamic confrontations. Police officers experience physiological effects in high-risk life and death situations that have to be taken into account in assessing use of deadly force.
You're familiar with cases like Graham versus Connor, Tennessee versus Garner, and obviously State versus White?
Yes.
Right. And those cases are what kind of help us decide what we look at in deciding whether force is reasonable. Is that accurate?
Yeah. I mean, Garner established the circumstances in which deadly force was reasonable. The Graham case established that use of force is a Fourth Amendment issue, and the objective reasonableness standard is the only standard by which use of force is to be assessed.
So how do you come to an opinion on whether or not a use of force was reasonable? What do you look at?
I look at whatever, as much as is available to me, forensic evidence, videos, witness statements, officer statements, whatever's about what is the prior investigation, and some cases what was known about the individual, what was learned about him leading up to the confrontation, what that individual did, as much as you can, and apply to make that determination as to whether the officer's perception of imminent risk that led him to use deadly force, decide to use deadly force, was reasonable in those circumstances.
Okay. And we look at what he knew at the time, correct?
Yes.
What does it mean when we say we don't review in hindsight? This sounds like we're judging him, we're looking in hindsight. Can you explain that?
Well, hindsight is when, if you take an event, say a shooting, and you have the result, and then you work back from that, and you say, well, if the officer had done this, or if the officer had done that, this wouldn't have happened, and then if the officer hadn't done this at an earlier stage, that wouldn't have happened, and the officer should have done this, and the officer should have done that. When often hindsight applies factors that the officer didn't know or couldn't know. When you examine a use of force incident, you need to move forward with the incident. And you look at what was known about the individual. You look at, again, forensic evidence, whatever you may have. You look at what the individual did, and you look at what the officer did in response. Now, if what the officer did in response was reasonable within those circumstances, that's okay. The officer isn't required to do the one correct thing you think he should have done, you know, a year after the fact. The officer's required and trained and expected to act reasonably based on the exigencies and the urgencies of the moment. And then you move forward through the incident that way until you get to a point where you can make a judgment as to whether the circumstances corroborate what the officer's perceptions were.
And you've mentioned in your report, you look at factors. We look at the totality of the circumstances, such as the severity of the crime. What's the importance of these factors? What are we looking at?
Well, different people have different levels of dangerousness. I mean, that's what you're looking for. The severity of the crime. You would approach an armed and violent bank robber a lot differently than you would approach somebody who was late on his child support payments. It's just, those are the factors that lead officers to make a judgment as to how much risk this particular individual or situation could embody, and hopefully be prepared accordingly. Risk rises and falls, and officers are trained and expected to recognize changing circumstances and react accordingly. You can't just initiate a response at the start of a confrontation and apply that response as a blanket response throughout a confrontation. It may well be necessary, but that's one of the things you need to look at is as circumstances vary, officers are trained and expected to recognize changes in circumstances and adjust their response accordingly, given physiological realities and time constraints.
Are factors, when we're looking at the use of force on the parties involved, factors such as a person's size or skill level, are those things important?
They are, again, depending on what the officer knows. An officer breaking up a drunken bar fight in a remote logging camp is going to react a little differently than an officer breaking up a drunken bar fight in a local university frat house. Again, it's what do they know and what can they reasonably surmise from the circumstances that they do know.
When an officer is trying to consider whether a person's a threat, are the things the suspect is saying to them important?
That's certainly an important factor. If a suspect, I always told my students and officers, if somebody's telling you they're going to kill you, it's okay to believe them. You don't need to wait for them to actually try to do so, to take some sort of protective action. It may not be shooting them, but certainly be on your guard and be prepared to respond more drastically than you may have thought you needed to.
And on the flip side, if someone said, I surrender, well, maybe you don't necessarily need to believe them. Should an officer consider that in the totality?
Yes. Again, it depends on what the person being confronted does. And if a person is resisting arrest and then gives up, the level of force being used needs to be adjusted.
And what does it mean when we say stop the threat?
It means ending whatever it is that threatens your physical safety, your health, well-being, your life, or someone else's. Now, the standard is that you can use deadly force to prevent an imminent risk of death, or actually, standard really, it doesn't even mention death, it says serious injury. And what is serious injury is often debated. Some states have statutorily defined, I think Alaska is one. I've done a couple of cases up there where they have a statutory definition of serious injury. I don't know what Ohio's, but that's the standard. You can prevent serious, now that means deadly force can be preemptive. You don't have to wait for someone to actually hurt you. You don't have to wait for someone to actually try to hurt you. Although many police officers do get to that point because they're reacting. But it means if the circumstances are such that, if you're approaching someone you recognize as dangerous, who has done dangerous, violent things, and is believed to have been armed the last time he did a dangerous, violent thing, and you approach him and he you tell him, raise your hands, and he does, and he reaches into his coat pocket, you could make the reasonable perception, it would be reasonable that he could do you harm, and you don't have to wait to see, because the circumstances support a reasonable belief that what he's doing could lead to harm. On the other hand, if you approach someone who's not dangerous, not violent, and you give them the same commands and they do the same thing, you're going to have to wait a little bit longer and maybe see what they pull out of their pocket. There's a higher level of risk you're going to have to take on yourself because there's no corroborating circumstances to say, yes, a perception of imminent risk of serious injury is reasonable in these circumstances. When, in that case, it wouldn't be.
So let me circle back a bit. So someone can no longer be a threat either because they stop the action, they maybe put their hands up, they maybe run away. Would that be accurate?
Yeah, or they've been shot and fall down. It behooves the police officer to recognize when the threat ends and stop applying deadly force. Now, frequently that takes a little time, again, because of the physiological responses and people don't react as fast as they do in the movies. So if somebody is posing a threat and the officer is shooting and it's a dynamic threat, and I'll tell you, no officer knows whether he's hitting his antagonist or not. You don't know. That's why they're trained to keep shooting till the threat ends, till they perceive that the threat ends, but it can take time. The individual can, if we look back at it, we can pinpoint a point and say, well, at this point, he's no longer an individual or a threat. But nevertheless, a couple of shots are fired a second or two after that. That's what you might call the biological, physiological inertia. An officer's engaged in a trained reflex, he's shooting, he's protecting his life, the threat disappears, and it takes maybe a second for that awareness to get through to him, and in the meantime, he's still shooting. So it's not uncommon for shots to be fired in the immediate aftermath of the termination of a threat. But again,
So what you mean is maybe shots 1, 2, and 3 hit somebody consecutively and there's still a 4, 5, 6 that come right along with it. Is that
Yes.
what you're referring to?
yes.
Okay.
But it'd be in they're in close succession. When police officers are shooting to protect their life, they shoot fast and they shoot a lot, which is what they're trained to do. And with modern weapons and modern training, a police officer can fire, 4 or 5 rounds a second. That's not unusual. And as long as that threat is there, they're trained to keep shooting. The old days, we used to train, well, fire 2 shots and then look and see if you need to shoot anymore. The realities of these confrontations change that. You don't shoot and assess, You shoot as long as that threat is apparent.
And so when we say until the person's no longer a threat, we're not saying shoot until they're dead.
No, no, just until the threat ends. Now, unfortunately, a lot of people do die because deadly force is that force likely to cause death. But the intent is not to kill them. The intent is to stop them posing or acting in such a way that they are a threat to the officers and others. And as soon as that action is stopped, the justification for deadly force disappears. They don't finish off the wounded.
So now let's get into this case. You were asked to take a look at this case and give an opinion as to whether or not the use of force was reasonable, correct?
Yes,
And you prepared a report.
I did.
I-2 is marked. I'm going to approach with State's Exhibit I-2. Tell me if that looks like your report.
Yes,
And you were given information from my office in order to prepare your report.
yes,
Did you feel you had enough information to make a decision based upon the materials given to you?
I did.
Part of that information was a synced up audio and video,
Yes,
and you had statements of Mr. Mitchell to review.
yes,
Looking at your report, you start out by discussing kind of a rendition of the facts of what happened here. Would that be accurate?
yes,
And I think you note that Mr. Mitchell was ill-prepared, I'm trying to find the exact language used, to perform his job. How is that relevant to the analysis here?
I think that that contributed to the resistance to the confrontation between the two. Police officers who are not in uniform are trained to have some, their official proof of authority, their badge or whatever it may be, depending on the jurisdiction. Because if you're not in uniform, there's nothing about you that says police officer. And people you approach in your official capacity may not believe you are a police officer, which can lead to resistance and can make whatever legal activity you may be involved in that much more difficult because you can't establish your bona fides as a police officer. In this, that's what I saw. It doesn't mean he didn't have the authority, and it certainly doesn't mean that his attempt to arrest her was invalid, or it just contributed to the difficulty of the situation. She didn't believe him. He's negotiating, trying to convince her that he is in fact a police officer, and this goes on for some time. That's what I mean by not prepared to really function.
And did you find in this situation that at one point in time, Mr. Mitchell may have been justified in using deadly force?
Yes, relatively immediately after the point he was injured. Clearly, there was a weapon. They were in close proximity. He was injured. I think if he had employed or decided to use deadly force fairly, at that point, it would have been, in my mind, it would have been a justified decision.
And are we assuming he'd been cut by Donald Castleberry at that point?
Yeah, he could be mistaken about that. I mean, she may have displayed the knife, and he very well could have been reaching for it and impaled himself on it. I don't know. But he wouldn't necessarily know that under the circumstances, and that wouldn't affect his perception that, the reasonableness of his perception that he had been attacked.
So you found that at one point, while he may have been justified, what was your opinion when the circumstances changed, and when did they change?
For me, the circumstances changed when, after he had been injured, and he opens the door, and I could see on the video that you can see his head outside the car, and you can see her moving into the back seat. Now, to me, that tells me that she's not attacking him. She's trying to get away, and that's as far away from him as she can get, is the back seat. And at that point, the circumstances are changing, and they continue to change. She's in the back seat, as far away as he can get. She's not. He suffers no further injury. She's verbally pleading and submitting and giving up. To me, that tells me that the confrontation has, whatever physical resistance she had posed or danger with a knife, she's submitting at that point.
And does the fact that he stated he was being choked with her foot in the front seat affect that analysis?
No. Yeah, I've had trouble picturing that. And once the door opens, he has room to remove the pressure. I mean, if she did have her foot up against his neck, just leaning out the door would relieve the pressure.
Does he have a duty? I mean, is that retreat? Does he have a duty to do that?
Oh, that's not retreat, no. I mean, retreat would be if he ran away. If he just said, never mind, go, But if he were to get out of the car, for example, he's gaining a tactical advantage. He has her locked in the car. She can't, child-proof locks, the driver's side door can't be opened. I'm not saying that he should have done that, but I'm just saying that would give him, it's not retreat. If he had gotten out of the car, it's gaining tactical advantage and buying time to address her and her fears and talk her down or get help or whatever would be necessary.
And are some of the factors we look at in judging this based on the totality of the circumstances, do we look at the ability to create distance and the ability to have time?
Yes, that can have an effect. You would expect a police officer under fire to take cover, even if he had to back up to do so. That's not retreating. But you do expect a police officer to recognize changing circumstances and be aware of the behavior and the behavior patterns of the person he's confronting and make judgments as to what level of force needs to be continued in order to bring them into submission.
And what if he doesn't recall that the door was open? How does that play into it?
I can't answer. I mean, the door was open. That's one of those objective facts you can look at. He opened it. He had to. Nobody else could have opened it.
So do we get to ignore evidence if an officer can't remember it?
No, you look at evidence and you have to make a judgment based on what that evidence means and how credible the officer's account is of what happened.
So we could still do an objective review whether he remembers that or not? Is that
Yes.
what we're saying?
Well, you have to. You have to do an objective review of any use of force. You can't just take the officer's word and be done with it.
Is there any objective evidence you found of the knife being in the backseat of that car with Donna Castleberry?
No, there's no damage to the car, there's no damage to the upholstery, there's no indication that she was trying to attack him. At one point, when he let go of her hands and was getting his gun out, if she were attacking him, I would expect there to be additional injuries. Close quarter knife fights, there's almost no way to engage somebody with a knife in hand-to-hand without getting cut. And the fact that he did not suffer any further injury tells me that, again, she was, in essence, retreating, not attacking.
And is it an important factor that the knife was found in the front seat?
It's an indication that she was unarmed when she was in the back seat.
What if he doesn't know where the knife is? He says he doesn't know. Does that give him the ability to presume that she's got it and she's a threat?
It's not uncommon for officers not to know things. And it wouldn't surprise me that he didn't know where the knife was. But the fact that he was not being further injured, further cut, and the fact that she had retreated to the back seat and her manner of submitting, pleading, giving up, he should have recognized that.
And what if he couldn't hear her pleas?
Again, he should have been aware of the changing circumstances. Her location, the lack of any attack. I think she's in the back seat kicking at him. I'm not sure that would rise to the threat level of justifying deadly force.
And where are officers trained to focus when they're dealing with somebody presenting a deadly threat?
Well, on the individual, most officers will focus on the weapon. It's amazing how many shootings end up where the individual wielding the weapon has wounds to his weapon hand because there's a phenomenon called tunnel vision, which when things get really dangerous and adrenaline kicks in, your subconscious kind of takes over and your field of view contracts. And that primordial being that we all have from our evolution is saying, that's what could hurt you. Focus on that. It's no longer a wild animal. Now it might be a gun or a knife. And in the extreme cases of tunnel vision, that's all they're aware of. They can see that weapon and they're focused on that weapon. With training and experience, officers can widen that field of view some, and they can look around, there are various measures that can be brought to bear, but it's common. It's one of the most common physiological reactions to a dangerous situation is the sudden tunnel vision. So most officers say they're looking at the suspect who presents the threat, and many of them are actually looking at specifically at the weapon that is being wielded.
Your report talks about the moment of decision to use deadly force. When you say that, are you talking about when the officer puts it in his mind or when he actually begins to start to...
No, when he actually makes the decision to begin shooting. When the assessment of a deadly force confrontation, the most important factor is that first shot. If the decision to fire that first shot is justified under the circumstances, subsequent shots are justified, almost invariably, because they're all part of a single event. What starts that event is what's key. And then, consequently, what ends that event is also an important consideration. If, it's common for deadly force to continue beyond a point where the threat is ended, but it wouldn't be acceptable for deadly force to continue minutes after a threat is ended, or, you know, long after the stress has ended.
So if an officer is feeling a threat at a certain moment and decides, I'm going to get my gun and shoot, but doesn't have his gun yet, and then circumstances change because he decided and may have been justified at the moment he thought about it before he reached for his gun, does he get to then later shoot?
Again, the act of deciding to shoot has to stand alone, independently of what the officer may have thought or said beforehand. If, at the moment he decides to shoot, the circumstances support a perception of risk, a reasonable perception of risk, it doesn't matter what he thought before. I mean, he may have thought, you know, the day before, I'm going to force a confrontation and shoot somebody, but he doesn't. And then he gets into a situation where somebody tries to injure him, and he does shoot them. You have to restrict yourself to that specific moment, not what went before.
You talk about Mr. Mitchell not issuing any commands. Are commands required?
They're certainly trained. Officers are trained to tell people what they want them to do and to keep telling them what you want them to do until they do it. And so it's unusual to see, to me it was unusual that he, from the moment he was injured to the end of the incident, he never said a word to her that I could tell.
So you didn't hear anything like, show me your hands, or things were?
No, or stop, or back off, or drop the knife, or,
Do you recall hearing profanity
yes.
from him? From Mr. Mitchell?
Yes.
Are officers trained to de-escalate?
Increasingly these days, there's an expectation that police officers will recognize changing circumstances and de-escalate accordingly.
At what point in this situation would there be an obligation to try to de-escalate?
More of I've not tried to call it an obligation, but an opportunity when she was in the back seat. By de-escalate, I mean, he had every right to arrest her. He had every right to physically try to handcuff her and subdue her. Her resistance was unlawful. That goes back to, again, being unable to authentically establish your authority as a police officer, but it doesn't mean he didn't have that authority under the circumstances. Once he was injured and she's in the back seat, you know, the opportunity to do something other than shoot her is in that time frame. And, you know, from once she has fled to the back seat and is verbally, if I don't, you know, no way to tell whether she was physically surrendering or not, but we could certainly hear her verbally submitting. That would have been the opportunity to de-escalate to the degree necessary, again, to bring her under control and effect the arrest.
So there was an opportunity to de-escalate early on before the handcuffing and the cutting occurred, and an opportunity to de-escalate when she was in the back.
Well, yeah, I mean, yeah, when he says essentially, fuck it, I'm going to handcuff you, that's drawing a line. And again, you know, that's within his authority. Don't get me wrong. May not have been the best decision at the time, but it was certainly within his discretion and authority.
And if he says, I was in fear for my life, or she was trying to kill me, do we end it there? Do we take his word for it and have to?
Well, no, you look at all the circumstances, the forensic, whatever you've got to corroborate that subjective statement. I'm in fear of my life by itself is not enough. It has to be supported by the facts, by an objective determination of what the forensics reveal you, by an objective look at what the suspect in this did, and what the officer knew about the suspect, and what the how that contributed to a risk of harm or not. Officers can be mistaken, and their mistakes can be acceptable. I mean, again, if it's the circumstances dictate, but I'm in fear of my life is not a magic shield that authorizes you to shoot anybody you want.
Let's talk a little bit about, you said an officer can shoot 4 to 6 rounds a second, I believe?
Yeah.
You've been a part of many, many cases involving officers' use of deadly force, is that right?
Yes.
And how does the shot cadence here comport with your experience and training?
It's uniquely slow and deliberative. Most of the only other case I've seen where there's a series of shots fired over a similar period of time was a case in Chicago involving an officer who shot a young man 14 times over the space of about 15 seconds. Actually, shot at him that period of time. And the young man had fallen down and was incapacitated after the first couple shots. We just continued shooting. Most shootings they're over quickly. And a lot of shots can get fired, but they're fired in a brief period of time, mere seconds. It's unusual to see, in this case, 6 shots spaced out over a 15-second period of time. That's unusual.
And you were aware that the gun jammed here,
Yes.
correct? So that gun couldn't have fired anymore if he had even continued to pull the trigger, right?
At that point, you'd have to clear the jam for it to continue firing.
And do you know a fellow by the name of Kevin Davis?
I do not.
So you're not familiar with any book or literature he may have written?
I've been made aware that he's written a couple of books. I know he's been retained by the defense, but I have no personal knowledge of him.
And did you review his report as part of your
I did.
work here? Did you find anything troubling in his report?
I'm trying to think. He expressed a greater willingness to validate the subjective experiences of the officers when the standard is an objective one, independently of that. And there's more, you have to look so much at what the suspect does and what the officer does in response to that and make a determination as to whether the officer's responses are corroborated, supported by that. And I found him unpersuasive.
Did you find whether or not he discussed the need to reassess or react to changing circumstances?
I don't believe he did, no.
Did the two of you disagree on the shot cadence here and the significance?
Yes. Well, he didn't find anything unusual about it. My question essentially would be, what would Miss Castleberry have had to do not to get shot at the point she's in the back seat? If she'd been shot at the initial point of injury, that would have been understandable. But I don't know what she could have done once she's in the back seat. What could she have done to avoid getting shot at that point?
You mean based on what Mr. Davis had to say?
Yeah,
There was nothing else she could have done?
yeah, apparently,
In his
yes.
opinion. And did Mr. Davis account for or acknowledge that the door was open?
I don't recall.
Okay, that's fair. I believe at one point, the term reasonably necessary appears in your report. You're not saying that reasonably necessary is the legal standard here, right?
Oh, no, no. But it is part of the objective determination when you are looking at a shooting, and this is what you folks will be doing. You need to make an objective determination as to whether it was necessary at whatever point.
So based upon your expertise, knowledge, training, years of experience and familiarity with the law, what was your opinion as to whether or not Andrew Mitchell acted in an objectively reasonable fashion in shooting Donna?
My opinion essentially is that his decision to use deadly force was not reasonable under the circumstances at the time he made that decision.
Nothing further at this time. I'm sure Mr. Collins has.
Councilwoman Roach?
The hall earlier today, correct?
We did.
Along with my partner, Caitlin Stevens, we represent Andy Mitchell in this case. First and foremost, I think you did some time for the Navy, correct?
I did.
Thank you so much for your service. Appreciate that. Second order of business, a good friend of mine, Jim Scanlon, said to say hello to you.
Jim is a dear friend and a colleague.
And you and he both testified together in State v. White, correct?
We did.
Okay. I want to start, sir, by just some basics of your past and stuff. You were never actually a police officer, correct?
Correct.
You were an FBI agent, correct?
Yes.
An FBI agent is subject to the Department of Justice policies, correct?
Yes.
And the Department of Justice policy for their employees has a different use of force standard or analysis than what we have here in the state of Ohio, correct?
They both stem from the same source. We're bound by the Supreme Court standards, and I think you'll find that they both they both say the same thing. They may use different words, but there's no difference in the tenor or intent of the policies.
We'll go through that. And you're aware that my client was a Columbus police officer, correct?
Yes,
Not a federal employee or a federal corrections officer.
correct.
And in terms of, you were never trained in OPATA or Ohio certified or anything like that in terms of law enforcement tactics,
No, I
correct?
was not.
Okay. And so first I want to look at your report, focus on some areas. Do you have your copy up there?
Yes, I do.
Okay. So if you could turn to page 3, you title a section of that, correct? And it's entitled Regarding the Use of Deadly Force by Officer Mitchell, correct?
Yes.
And then when you go to page 4, in the second paragraph, you use the phrase, law enforcement and correction officers ... may use deadly force only when necessary, okay?
Yes.
Now that ... you left a lot of stuff out, correct? In that ellipse.
I'd have to go back and look. I don't know what that took out.
Okay. May I approach the witness, Your Honor? You may. Now, you're, on that page 4, Mr. Patrick, and at the bottom, you're attempting to show that a policy by the Department of Justice somehow flows through Ohio, somehow flows to the Columbus Police Department's use of force, correct?
No, I'm not. I'm attempting to use the Department of Justice policy statements to explain the standards that apply to everybody,
Perfect.
all police officers.
May I approach, Mark?
May?
I'm handing you, just for identification purposes, Defendant's Exhibit 16.
Mhm.
Could you take a look at that, sir?
Yes,
And you know what that is, correct?
yes,
And that's Department of Justice policy with regards to lethal force, correct?
yes,
Okay. And that's what you were referring to in your report that you footnoted and you talked about on several pages, correct?
yes,
And that says in the first sentence, law enforcement officers and correction officers of the Department of Justice.
yes.
So that applies only to them, correct?
It is a Department of Justice policy, yes.
Correct. And so nowhere in Graham v. Connor does the term reasonably necessary appear, correct?
Correct.
Nowhere in State v. White does the term reasonably necessary appear, correct?
I haven't read State v. White in years. I couldn't answer that off the top of my head.
Would you like to read it?
No,
Okay. Would you take my word for it that it doesn't appear there?
I will.
Okay. And in that situation, sir, you still put it into your report, the wording about necessary and reasonable necessary on page 4 in the second paragraph, right? Right after the ellipse, may use deadly
Yes.
force when necessary,
Only
right?
when necessary, yes.
Okay. But again, you just agree with me that it's not in the constitutional law of Graham v. Connor, and it's not anywhere in the state of Ohio's seminal case, State v. Ohio, correct?
I can't imagine that Ohio wouldn't want the deadly force to be necessary.
That wasn't my question, sir. My question is, Graham v. Connor controls State v. White for the state of Ohio, correct?
Yes,
And nowhere in there does it use the words reasonably necessary or necessary, correct?
correct.
You put those words into this report, correct?
Because I was quoting the Department of Justice policy, yes.
That only applies to federal law enforcement officers and correction officers, correct?
Yes,
And you're aware he's not that, correct?
yes.
Okay. Other things that you didn't put in your report, or that you do in the report. All right. Let's go to nowhere, you talked to Ms. Pritchard a little bit about an officer can be mistaken, right?
Yes,
They can be mistaken about a belief, correct?
yes,
As long as that's reasonable, correct?
yes.
And nowhere in your 8-page report do you ever mention the term mistaken belief where an officer can be mistaken, correct?
Correct.
You specifically left that out of your report. Correct?
I didn't, yes, I did not, I didn't use that term because I didn't see any reason to.
You didn't anticipate that potentially Mr. Mitchell's belief could be mistaken about whether or not Ms. Castleberry was a threat in the backseat, or whether or not the door was open, or whether or not she was a threat as she passed by him? That's common sense, correct?
Yes.
Very good. Next, on page, your timeline events, okay, on page 2, if you go to page 2, sir. All right. Paragraph 3, okay? And Mr. Patrick, I apologize. Sometimes I go very fast, so at any time if I go too fast, please let me know, all right?
Sure,
Okay. So are you with me now at the timeline on the paragraph 3 on page 2?
yes,
And you walk through different things about what you hear, correct?
yes,
Different things at times of what you see, correct?
yes,
Now, when you base that timeline, you're basing it on information you've reviewed, correct?
this is based on the video, yes,
Okay, but you had reviewed my client's written statement, correct?
yes,
Okay, you had reviewed his testimony under oath at prior times, correct?
yes,
And at nowhere in that timeline do you mention anything about the choking situation, correct?
correct.
Okay. You were aware of it, right?
I was aware of it, yes,
Okay. And you mentioned to Ms. Pritchard on direct that you had a hard time visualizing that, right?
yes,
Okay. So let's try to hypothetically, I'm seated in a seat and I'm belted in, okay? I have my seatbelt on. You're aware Mr. Mitchell had a
Yes.
seatbelt on, correct? And Ms. Castleberry had her seatbelt off, correct?
yes,
Okay. And at some point in time, there was a struggle over the handcuffs, correct?
yes,
And at that point in time, he's still seatbelted in, correct?
yes,
And at some point in time, there's a struggle, right?
Yes,
Non-compliance by Ms. Castleberry to being under arrest.
yes,
My client announced that he was going to place her in handcuffs, right?
he did.
Long before he said F you, right?
Yes,
Long before that. Then he tried to handcuff her, correct?
he did.
There was a struggle, right?
Yes,
And then on your timeline, she's got a knife, she cut me, right?
yes,
Based on what you read in my client's statement as well as his testimony, you then realized that my client had a struggle with her to gain control of the knife, correct?
yes,
So both his hands were to both of her hands, correct?
yes.
She positioned herself so that her back was up against the windshield, and he had both hands like this, right?
That's what his account says.
And I'm just trying to help you visualize it because you told Ms. Pritchard you couldn't visualize it very well. So now, he indicated that as he pulled to gain control of the knife, her foot was underneath his neck, correct?
Yes,
And the more he pulled, the more he thought he was going to lose consciousness, correct?
yes, that's what he said.
Okay. And were you aware that his DNA was found on the bottom of the sandal of the foot that was under his neck?
Yes,
Okay. But you didn't look at that objectively, did you?
I saw what I saw in the video. I didn't see this timeline is based on the video.
Sir, I'm asking you if the fact that my client, in this report several times, you say his statement alone isn't enough, correct?
I said his statement needs to be corroborated by the circumstances and evidence available.
Would you agree with me that the DNA on the bottom of a sandal of someone who says that the foot was underneath his neck and squeezing it, that's corroboration, right?
That's indicative that she did that, yes.
But you don't put that in your report.
I did not.
You don't tell that to the ladies and gentlemen of the jury, do you? You discount it, right?
I didn't assign any relevance to it for the decision to use deadly force.
That's his perspective, right? You
Yep.
have to address it from his perspective, correct?
In part, yes.
Yes. And so at the time, when was his decision made to use deadly force, Mr. Patrick?
Why?
No, at the time, wasn't his decision to use deadly force right before he lost consciousness, correct? That's when he decided, hey, if I let go of these hands, she might slash me, but I can try to get to my weapon, right?
He did let go of those hands to get his weapon.
Correct. So at that time, he made a choice to use deadly force, right?
At that, again, as I said before, the critical point is when the deadly force is the gun is actually fired. But yeah,
In order to fire the gun, I apologize for interrupting. In order to fire the gun, you got to get the gun, right?
yes, you do.
You're not getting the gun.
But the fact that you're getting the gun doesn't commit you to shooting the gun.
The fact that you're getting the gun doesn't mean you're going to wave it, right?
I've seen people do just that.
Okay. Now let's put in the other factors. He's been slashed on a cut that goes down the gash of his hand, correct?
Yes,
Okay, 34 stitches, correct?
yes,
That happened first, right?
yes,
Now he almost is losing consciousness as he's getting choked out, right?
according to his account, yes.
And the corroboration of the DNA that you said is indicative of that, correct?
Yes.
That you didn't consider, correct?
The DNA does not indicate whether he was losing consciousness.
Okay. So he's lying about almost losing
I'm not saying he's lying. I'm just saying that's his account.
So at that point in time, when he lets the hands go, that's a risk, right?
Yes, it is.
That's an increased risk caused by Donna Castleberry, correct?
It is an increased risk, and my point earlier was that when he...
I don't mean to interrupt. My question was, that was an increased risk caused by Donna Castleberry, not my client, correct?
Under the circumstances, when he let go of her hands, he enhanced the ability of her to attack him, yes.
He did, and he enhanced the ability of her to attack. She could attack him as she came closer to get to the back seat, right?
She could have.
In his mind, and that's reasonable, right? For him to believe that.
But she didn't.
That's not my question, sir.
No, but that's the answer I can give you.
No, the question is it reasonable for him to believe that after he's been sliced once and after he's choked, as he lets go of arms. You just said it increased the risk of the chances of her enhancement to attack him, correct?
Yes.
So if I've been slashed once and choked, it's reasonable for a police officer to believe that as she comes towards me to get to the back or here, she could slash me, right?
That's possible, yes.
And it's reasonable, right, Mr. Patrick? We're not dealing with possibilities.
It could be reasonable.
Yes. And it's reasonable that if someone is more dangerous behind an individual than they are from in front of them, correct?
Again, depending on the yes, it's possible to be more dangerous behind. But this was not a surprise attack. This was not an ambush. She was retreating from him.
Sir, a surprise attack? He never saw the knife the first time. That's a surprise attack, correct?
That was.
So you did, but, okay. So, but if I'm confronting someone and I can see them, the risk of injury to myself is far less than if they're behind me and I can't see them, correct?
Correct.
Okay. So someone is more dangerous if they're behind the officer than in front of them, correct?
In general, yes.
All right, I want to switch gears, okay? And talk about threats, all right? You would agree with me that attack with a knife is violent, correct?
Yes.
You would agree with me that verbal, I'm not going to be handcuffed, is a sign of noncompliance, correct?
Yes.
Resisting is a threat indicator, correct?
Yes.
Physical assault is a threat indicator, correct?
Yes.
All danger cues, correct?
I'm sorry.
All danger cues, right?
Again, it depends on the circumstances, but yes, people resist, some are dangerous, some aren't. It's an indicator of certainly that you have to take into account.
Okay. And you would agree with me that you've testified under oath before that the moment the baseball bat hit the other individual, that shows an intent or a desire to harm the officer or kill the officer, correct?
Baseball bat?
Yes, sir.
I'm sorry, where's that coming from?
Okay. You had previously given a deposition before in a state of Jonathan Fontes versus Broward County Sheriff's Department, correct?
That's been a while. I don't remember
Okay.
the details.
Do you remember that the suspect had a bat and was trying to hit officers?
I don't remember anything about the case at this
Okay.
point, but I'd be happy to review it if you like.
Absolutely, absolutely, okay? So I'm going to turn to page 114. And for identification purposes, we've acknowledged this as Defendant's Exhibit 15. No, there's no copies. We have no intention of admitting it. I'm doing it for the record, the purposes of the record. I'm going to give it to him. No. So we approach, Your Honor.
No, just continue. We'll get copies if need be.
May I approach the witness, Your Honor?
Nay.
Okay. You're familiar with when you testified in the estate of Jonathan Fontes versus Broward County Sheriff. It's, take a look at this, I'm sorry.
Okay.
Okay. And you were under oath, correct?
I don't recall, yes, but I don't recall the details.
Okay. All right, well, I'll turn to page 114, okay? And you can go ahead and read a question or two. Take your time and read that page, okay?
Okay. Yeah, and I agree with that.
But tell the ladies and gentlemen of the jury, you actually say that at the moment the bat makes with the individual, the suspect's intention is clear that they're going to continue to harm, to cause serious physical injury or death,
This
correct?
yes, in this case, I will quote from this document, "The accumulative effect of his behavior," the attacker, I'm presuming, I really don't recall this, "his continuous fighting, his continuous resistance, his aggression." You know, the moment he hit Wagers, the police officer, in the head with a baseball bat, he established that he was willing and intending to kill that police officer.
And you agree with that, correct? Mr.
I do.
Chairman?
I do.
Now let's relate it to this case. Donna Castleberry resisted, correct?
She did.
She continued to resist, correct?
She did.
She fought with him, correct?
She did.
And then she took a knife out and she slashed him and committed a felonious assault, correct?
He was definitely cut. Again, as I mentioned earlier, whether she did it intentionally or he did it grabbing for the knife, he was cut, and he was reasonable to think that he was at risk at that point.
So just like the person making contact with the bat, Donna Castleberry made contact with a knife in my client, correct?
She did.
Okay. So you agree with that, that fits that same scenario, that there is now a belief in my client, and it's reasonable that the attack, that she's going to continue, or that she's going to seriously physically injure him or cause death, correct?
I think it would have been reasonable for him to look for a continued attack, yes.
Okay. And that's reasonable, to look for a continuous attack after you've been slashed, after you've been choked. You have to believe that the attack's going to continue, correct?
Yes,
Okay.
and that's why I said it would have been reasonable for him to use deadly force at that point.
Okay, so let's talk about that. So eminent, when we talk about eminent, right? Eminent means something's going to happen soon, correct?
Well, it could happen. Doesn't
happen.
mean it's absolutely going to happen.
Possibly, right? That's what
Yes.
the word, that's how you use eminent in your,
Yes.
in your analysis, right?
Yes,
And eminent, and you remember the Laquan McDonald case that you testified in?
yes, in Chicago?
Yes.
Yes,
Okay, so you testified that when you use it, it means something could happen soon, right?
yes,
Okay. And you would agree that a person who is unarmed can still be a deadly threat, correct?
yes,
You would agree with me that an officer is authorized to shoot to prevent an imminent attack from becoming an actual attack, correct?
yes.
So had Andy Mitchell, now, Miss Castleberry didn't have the knife in her hand when she got in the car, right?
I don't see any evidence. No, I'm sure she didn't.
And have you examined the knife or looked at pictures of the knife?
I've seen pictures.
It's a knife that you have to hit a button to open, correct?
Yes,
Pretty big knife, right?
yes,
A knife that's common sometimes in those circles with prostitutes and drugs and the dangers of that profession, correct?
that I couldn't speak to. I don't move in those circles. I don't know whether knives are common with prostitutes or not.
What you're trying to say to the ladies and gentlemen of the jury is you've never been in a situation where you've had to lawfully arrest prostitutes, or you've had to work those areas because you were in the federal government.
I've arrested violent criminals, but I've never arrested a prostitute.
Right, that's what I just asked you, correct?
No, but that's what you implied that being at the federal level, I didn't arrest anybody who was dangerous.
No, I didn't. I asked if you ever arrested someone in a
And I
prostitution
said,
type
no,
scenario.
I did not.
Right. And so, had he seen the knife ahead of time, under your theory of the perceived imminent threat, he could have shot her before he got slashed and be justified.
It would depend on what she did with the knife.
Hypothetically, Mr. Patrick, then he sees her with a knife, he sees the knife coming at her, if he was able to, he's allowed to shoot and use
That would be justified, yes.
May I finish my question? He's allowed at that point in time to use deadly force against her before he receives an injury, correct?
Yes,
Okay. And then you also testified to Ms. Pritchard that he's allowed to do that recently right after that, correct?
yes.
After receiving it. Okay. Okay. I want to turn a little bit now to a different topic, your book, okay? Some of the concepts that you talk about in your book.
All right.
Okay, I have a copy here if you need it, if you'd like to refer to it. You
I
believe
don't.
in the things that you say in your book, right?
I'm all right.
You believe and adhere to the principles in your
Yes.
book? Okay. You're proud of this book?
Yes,
Okay. And you reference it many times if you testify or if you're trying to form an opinion, correct?
Yes.
Okay. Now, on page 83, it's a section that you list called irrelevant factors, right?
I have not memorized the book. I couldn't tell you if it's on page 83 or not.
May I approach the witness, Your Honor?
You may.
For the record, it's just for identification purpose, Defendant's Exhibit 22. Sorry about the highlights, Mike.
No, don't
Pardon
worry.
me. That's a copy, I apologize, that's a copy of your book, correct?
Yes.
Other than some of the notes aside as a highlighting, that appears to be the same as it was. previously.
Okay.
All right, so on page 83, you talk about irrelevant factors, right?
Yes.
The first irrelevant factor is the subject intent of the officer, correct?
Yes.
It doesn't matter what the officer thinks, correct, in terms of the subjective intent.
Yes, I think I had that same conversation with Ms. Pritchard.
And Graham v. Connor explicitly prohibits that, correct?
Yes.
Okay. And so the second one factor, irrelevant factor, is the subjective intent of the suspect, correct?
Yes.
And there you say, not allowed. It doesn't come into the analysis of whether or not force is reasonable, correct?
Correct.
It's an irrelevant factor.
Yes, because
Okay.
it can't be known.
All right. So, and they are irrelevant, and you've also testified and given a quote, or in that book, I'm sorry, an officer's intent is irrelevant because the standard is reasonableness. The standard intent is irrelevant, the suspect's intent is irrelevant, and I quote, because it requires very little mentation to be dangerous. Even a rattlesnake is dangerous, but does not possess the requisite mental capacity to be prosecuted for homicide. You've said that in your book, correct?
Yes.
Okay. So the intent doesn't matter for the suspect, correct?
Yes, it's not, because it can't be known.
It's an irrelevant factor.
Yes.
Okay. However, in your report, you refer to intent of Ms. Castleberry in your report. Do you have your report there, sir?
I do.
Okay. And in your report, page 2, paragraph 2, the first sentence there, sir.
Yes.
Castleberry did not believe he was a police officer, right?
Yes.
You're inferring intent there, correct?
I thought I was just repeating what she was saying. I mean, it's evident from the video that she didn't think he was a police officer from the soundtrack.
You're an expert that testifies all over the country, and you're an expert that your words matter in your report. And your report says Castleberry did not believe. You're making a determination in your mind that she didn't believe him, correct?
I did, yes.
And that's exactly opposite what you say in your book. An irrelevant factor, correct, Mr. Patrick?
I don't, intent to cause harm is unknowable and irrelevant. A rattlesnake is dangerous, but can't form the intent to hurt. The fact that she didn't think he was a police officer was manifestly obvious to me, and that's why I mentioned it.
Okay, obviously to you, it manifests obviously. Let's
Yeah.
talk about that for a second. So, were you aware that she had a warrant out for her arrest on August 23rd of 2018?
After the fact, yes. I mean, after I've looked at the incident, yes,
Well, sir, you wouldn't know it before the fact because you didn't get it till about a year or two later, right?
correct.
So were you aware that she had all sorts of high amounts of narcotics in her system?
I wasn't at the time. I have since been aware that she was,
I'm having problems with at the time. What do you mean at the time?
that I wrote this.
So you wrote that without knowing that you had the case file with you, correct?
I did, yeah,
You had the coroner's report, correct?
yes,
In the coroner's report, there's a toxicology part that says high levels of cocaine, fentanyl, and a veterinary drug, correct?
yes.
So when you wrote that report, you didn't even know that she was on that stuff?
No, I had seen the report.
You just told, ladies and gentlemen,
Yeah.
that you didn't see that stuff when you wrote the report. You found out after. Had you known that before you wrote the report, you probably would have included it, right?
I would have, yeah,
Might explain noncompliance, correct?
might have,
Might explain why she resisted so hard so she doesn't have to go to jail because she's dope sick, right?
might have,
Might have explained why she tells him on the audio tape going to that direction, I got to score some dope, right? Overruled.
yes,
Okay, So had you known all those things, you probably would have said, geez, the form of noncompliance, her irrational behavior, all of those things might explain why her manifest belief that he wasn't a police officer, correct?
I might have, but I mean, the fact that she was on dope doesn't mean that she was more predisposed to disbelieving his status as a police officer. I don't, and I've never denied that he had the authority to arrest her or to confront her.
We're not talking about his authority to arrest her or confront her. We're talking about her physical actions towards him, what he perceived, correct?
Yes.
You indicated that you believe, in your report, you said her intent, Donna Castleberry, did not believe he was a police officer. Had you known that she had a warrant out, and in the state of Ohio, then, I think in other testimony I've seen, when there's a warrant out, you have to take him in, right? There's no discretion.
Yes.
Did you know that there was a warrant out for her when you wrote the report?
Yes.
Okay, so because there's a warrant out, because she has a drug system, it probably makes sense that she doesn't want to be incarcerated, correct?
Yeah.
That's a reasonable thing to believe, correct?
Yes.
But you didn't take that into your consideration of her belief whether or not he was a police officer, correct?
No, I did not.
Okay, and then in terms of, you mentioned on direct something about the fact that he was undercover, right? Led to some issues that he was ill-equipped to do, right?
Yes.
Okay. Isn't it true, sir, in that same deposition that you told someone let me just ask you, would you agree with me that whether a police officer is in uniform or undercover, it does not factor into the decision to use deadly force?
Correct.
Doesn't matter if a person was working undercover or not without his badge, correct?
Correct.
That has no bearing, and you testified that before under oath, correct?
Yes.
So all this intent about whether he had his badge or not badge, or whether she believed him, that doesn't matter according to you and your prior testimony, correct?
I wouldn't characterize that as intent, but no, it doesn't matter.
You just said she didn't, you believe her intent was that she didn't believe he was a police officer.
I think that was her belief, but there's no intent there. I mean, intent implies some planned action, some intended goal.
The intended goal is not to go to jail, right?
I think, yes.
Okay, and so. Okay, so we've talked about the irrelevant factors of the intent on each party, correct?
Yes.
Now, you would agree with me that officers are trained, and I think you said a little bit of this, officers are trained not to injure, correct?
I'm sorry.
Not to injure, correct?
Not to injure?
Officers are trained when they shoot not to injure somebody. They don't.
You can't shoot somebody and not injure them.
Sir,
Maybe you need to, officers are trained not to shoot to wound. Is that what you mean?
There you go, yeah.
Well, say that. You can't shoot somebody fatally or non-fatally without injuring them.
Sure, but a wound is an injury, correct?
Yes.
Okay, so officers aren't trained to wound somebody, right?
They are trained not to shoot to wound, yes.
Officers are trained not to kill somebody, correct?
They're trained, the intent is not to kill, but yes, they are trained to shoot at the center of what they see.
And they're trying to make the suspect incapacitated so the threat stops, right?
Correct.
So you would agree with me that officers are not trained to kill somebody?
I agree.
I want to switch gears a little bit. You mentioned about some law enforcement concepts with Ms. Pritchard. You would agree with me that officers are not required to engage in a verbal warning when using deadly force, correct?
Correct.
They're not required to, and that's in your book on page 226, right?
Among other places, yes.
Okay. And you also indicate that verbal warnings are notoriously ineffective in resolving physical confrontations, correct?
Yes.
Okay. However, on page 5 of your report, if you want to go to there, the third paragraph, first sentence.
Yes.
You criticize Mr. Mitchell for not giving a verbal warning, even though it's not required.
Yes, I'm noting, I mean, it's unusual for officers not to issue verbal warnings.
Well, it's not
They're
required.
not, it's not required, but it is unusual.
And in your own opinion, you just said that it's, quite frankly, not very effective, right? Notoriously not effective.
It is.
Okay. I want to talk in terms of eminence and the perceptions of a law enforcement officer, okay, in terms of their training with regards to lethal force being used against them, all right?
Okay.
Tell the ladies and gentlemen of the jury what the lethal reach concept means with a knife.
I'm not sure I've used that term.
Okay. Have you ever testified that a person's lethal reach is well beyond their arm's length?
Yes, a person with a knife is dangerous beyond arm's reach.
Wasn't that the question I just asked?
Your inartful terminology threw me.
Okay, so let me try if I can get it correct. The concept of lethal reach means that it is much further than a person with a knife extending their arm, correct?
Again, I think we're talking about the same thing, but a person, because of the action-reaction cycle and because of the individual denial and physical delays, a person with a knife can be dangerous. In other words, get to you and injure you with the knife far beyond arm's reach.
Distance and time matters.
Yes.
The attack can reach the harm of the victim regardless of the victim's reactions and responses, correct?
Yes.
Okay. And lethal reach, actually, you use it and define it as distance and time within the attack can reach and the harm the victim regardless of the victim's reactions and responses, correct?
Yes.
It involves the physical surroundings of the event that it occurs in, correct?
Yes.
Okay. So in this situation, were you able to go out and view the car?
I have not seen the car.
And your report is dated?
I mean, I've seen photographs of the car, but I've not. The report is dated June 28th, 2020.
June 28th of 2020, so 21, 22, so roughly 34 months have gone by and you didn't go see the car?
I did not.
Okay. Do you have the measurements off the top of your head of the car, the inside of the car?
Not off the top of my head, no.
Did you review any measurements?
Just what was in the file, the forensic.
If I told you there's no measurements in the file, would you disagree with me?
No?
You just looked at the pictures, correct?
Yes.
Okay. Is it fair to say that that entire encounter, that the two parties were never outside of an arm's length away from one another?
Yes.
Okay. And the closer the proximity is to somebody, the more dangerous the suspect is to the officer, correct?
Yes.
Okay. Now, you're aware after reviewing my client's written statement and testimonies that my client believed that when he let go of her arms, that she still had the knife, correct?
Yes.
Okay. And that's a reasonable thing to believe, correct?
Yes.
Okay. And then, as indicated, Ms. Castleberry came towards him to get in next to him, correct?
Yes.
So if my client had a reasonable belief that she still had the knife when she went in the back seat, it's reasonably for him to perceive another imminent threat, correct?
Yes.
May I have a moment?
You may.
Carla, could you read back that question and answer for me, please?
So my client had a reasonable belief that she still had the knife when she went in the back seat. It's reasonable for him to perceive another imminent threat, correct? Answer yes.
That's what they're trained to do, right? To perceive that. That's reasonable for him to believe that, correct?
They are trained to recognize circumstances and suspects and what they do and respond accordingly, yes.
So at that point in time, when he gets the gun and starts to fire, You're saying that he's not justified? You just said that it's reasonable for him to believe that she's an imminent threat as she goes from the side to the back.
Yes, and then things changed. The circumstances continued to evolve.
Let's talk about things changed. You can't see anything in that back seat, correct?
Correct,
You don't know what she was doing in that back seat, correct?
correct.
Have you reviewed the paths of the bullets?
Yes,
Okay, one is going upwards to the left, correct?
yes,
One is going downwards to the right, correct?
yes,
One is flat, right?
yes.
That's consistent or corroboration of objective stuff that the person's moving around, the target's moving around, correct?
Or it's evidence that the police officer is firing unaimed shots from an awkward position where he can't bring his sights to bear.
Not the question I asked you, but I appreciate the answer. The question I asked you is that the different angles of where the bullets are going is common sense consistent with the target might have been moving, correct?
That is a possibility, but the most likely one is that the police officer, under stress, when officers get into shooting situations, their firearm skills diminish drastically.
So
They-
now you're determining what's most likely in these scenarios? Isn't that hindsight, sir?
No,
You're trying to say it's
I'm looking at the spread of the shots, and that's what I would expect from a severely stressed police officer.
You realize from the coroner's report that she had soot and stippling in her leg, correct?
Yes,
Okay, and that comes from a gun has to be from 0 to 18 inches, correct?
yes,
Okay, and one of your premises, a premise that you have is she's just sitting in the back center, right?
I don't know whether she was just sitting there, but
Well, wait a minute, in two or three
I mean,
places-
she's pressed, she's in the back, she's retreated as far as she can get.
Sir, 2 or 3 times in your report, you say as she was seated in the back seat, correct?
Yes,
Okay, if someone's seated in the back seat, let's go into that premise, right? Now, in order to get a wound in this part of your shin, you see where I'm pointing?
yes,
That bullet came out of the calf, right?
yes,
And then it went up into the thigh, correct?
yes.
That would be impossible to receive that wound if you were sitting in the back seat, correct? The bullet would have left the calf and went into the seat that
It
they're
would
sitting
depend
on.
on where her leg was and how it was bent and but I'll guarantee, I'm sure she was still sitting in the back seat, even though her legs may have been bent or moving.
Exactly, so you don't know where she was and if she was sitting. You don't know if she was standing up hunched over. You don't know, correct? If she had the knife and was swinging it at him in the back, correct?
I don't know that.
That's reasonable that it could have happened, correct?
My review of the circumstance, no, but it could have happened, yes, but I don't think it's likely that she was swinging the knife at him from the back
And
seat.
is there anything in Graham v. Connor and State v. White that gives an expert the authority to say, I don't think it's likely, sir? You've never, that's not in Graham v. Connor, it's not in State v. White, correct?
No,
There is no standard that says it's probably the most likely thing, because you're speculating about everything, correct?
no, because I'm rendering an opinion based on the numerous shootings and the analyses I've done. It's I'm not a Graham v. Connor participant, but I am taking the standards and trying to explain how they are applied and rendering an opinion as to whether something was justified or not.
Your opinion is on whether or not there was a reasonable belief of serious physical injury and whether or not that objectively was reasonable. That's the standard, correct?
Yes,
There is nothing in any of the analysis that says you have the task of determining what happens in a car that you can't see, that you don't know, that something's more likely than the other. That doesn't exist in any analysis regarding the case law, correct?
correct.
You're making that up, correct?
Making it up?
That's hindsight, correct?
That is applying my judgment and experience to what is available in the forensic record and coming up with an opinion.
And you read in my client's statement that he believed as she went from the back seat next to him and back seat, that she was still a threat and she was grabbing her arms, moving her arms, kicking and stuff like that, correct?
Yes,
Okay, so that doesn't sit with someone sitting in the back seat, correct?
I didn't imply or say that she was sitting there passively. It's quite possible and likely she was moving. I have no question that she was moving her arms and legs.
Let's talk about the knife. You make a logical inference that the knife was recovered from the driver's side front seat, so therefore, at some point, she abandoned the knife. That's what you said in your report, correct?
Yes.
You have no idea when that occurred, correct?
Correct,
You have no idea how that occurred, correct?
correct.
You're making a huge assumption on that in an inference, correct?
I'm making a logical inference,
Right.
as I said.
And you're trying to say that because of based on what you heard from the audio tape, that she was pleading or stopping her attack, correct?
Yes,
Okay. And you can't say even close that my client heard that, correct?
I cannot.
Have you been in a side of a vehicle when the weapon's fired?
Yes,
Okay, and how did that sound?
it's loud.
You can't hear, right? Second shot, third shot, all that has damage to your ears, correct?
It stuns your hearing,
Okay.
yes.
So we've had officers already testify, sir, that they can't hear that type of stuff. That's not unreasonable, correct?
No,
Okay, but you rely upon her statements and assume that he heard them, correct?
I rely upon her statements because she said them.
Okay.
Now, I don't assume that he heard them, but it is part of the objective analysis you have to do to look at all the factors and the circumstances.
And nowhere in your report did you, in your objective analysis, did you say, hey, by the way, I'm not saying that Andrew Mitchell heard these. You didn't address anything on the other side, correct? With regards to that.
With regards to him hearing it, no.
You didn't put anything in there, and that's basic common sense, correct?
I can't answer whether that's basic common sense or not. How you
Using your
characterize-
own words, it's the most likely thing that he didn't hear it, right? Based on the trauma inside of a car with a gun going off 6 times, correct?
Quite likely,
Most likely?
most likely.
You would agree with me that when she was armed with a knife, she's definitely an imminent threat, correct?
Yes,
Okay. You would agree with me that she continued to fight, she continued to resist prior to the slashing with a knife, correct?
yes.
You would agree with me that she's the aggressor, correct?
She's aggressively resistant. Yes, I mean,
She's elevating the force, correct?
she is elevating resistance, yes.
Okay. So when you make arrests in general, when you have probable cause and you have those elements, is it fair to say that the best arrest is where they don't know that you're an officer until you put their hands on them, correct?
Yes,
Okay. So what you just said was the best use of force to lawfully arrest someone is if they don't know you're an officer and you put their hands on them because that's the quickest way to ensure the safety of both, correct?
yes,
And you would agree with me that you don't have to announce yourself as a police officer in that situation, correct?
yes,
Okay. So those are the best ways to do that, correct?
yes.
And with regards, now, I believe that in a situation like this, where you have 6 shots, right?
Yes.
We can't tell the order of the shots.
You mean as far as where they hit?
Yeah.
Yeah, no, we cannot.
We can't tell where shot 1 went or where shot 6 went,
No.
right? There's no possible more likely or anything like that, correct?
No.
Okay. And however, when someone receives a wound, as Ms. Castleberry did, receives the infliction of a gunshot wound. Well, let's keep it general first, I apologize. In general, when someone receives a gunshot wound, they can still be lethal, correct?
Yes,
They can be lethal because their body takes over. And the things in their body, the survival, to survive kicks in and makes pain
yeah,
oblivious.
yes, I agree, but it's more complex than that. They may be unaware they've been shot. They may just have the will to fight. But there is, yes, people can receive a mortal wound and still be dangerous until the effects of the wound accumulate to the point where they overcome whatever mental or physical resistance
And
they
that
have.
can take a long distance of time, correct?
It depends on where the wounds are inflicted.
Correct. And so, just because someone receives potentially what's a mortal wound, doesn't mean that they can't, at that point in time, still be a deadly threat.
That's correct.
Now, let's talk about the cadence, okay? Well, let's talk about the cadence, okay, of the shooting, correct? Now, a lot of the stuff that you rely upon when you say an officer can shoot in 4 to 5 rounds in a second, that's what you said, correct?
Yes.
That's based on studies in a sterile environment, correct?
That's based on actual shooting incidents.
Sure, a combination of both, right?
Yes.
There are studies that are done in the sterile environment to see what the reaction time is and the cadence time, correct?
Yes.
There's also review of cases in which an officer is fired a certain amount of time, correct?
Yes.
All right. In this situation, would you agree with me that the fact that Mr. Mitchell was slashed and received 34 stitches, immediate surgery and blood transfusion, that probably would have affected how long it took him to pull the trigger, correct?
With that hand.
Correct. Well, you read his statement, right?
Yes.
And he tells you in his statement that he tried to fire with that hand, right?
Yes, and he fired with the other hand.
So my question is, sir, someone with that type of injury is not going to be able to fire 4 rounds in a second, correct?
Correct.
Okay. So there's going to be a delay from one round to another. Or as you put it in your report, a pause. That he paused. He deliberately paused. That's how you phrase it in your report, correct?
He did pause, yes.
But you don't put anything in your report, or you don't talk about the ladies and gentlemen of the jury about cadence, saying, hey, you know what? He was injured, and when he first tried to shoot, he shot with his injured hand. That's definitely going to slow it down, correct?
Yes.
And how long depends on how severe the injury, correct?
Yes.
How fatigued he is from the struggle, correct?
Yes.
If he has any breath left while after being choked, correct?
Yes.
The trauma of the event, correct?
Yes.
Some people, it might help them shoot faster, right?
Yes.
Some people, it might slow them down, correct?
That's unusual. That would be unusual.
That an injury of 34...
No, that people would, the stress of the, you were talking about the stress of the incident slowing them down. And
People react differently to the stressful situation.
they do.
The times are differently, right? So then, he switched the gun from his left hand to the other hand, or the injured hand to the other hand, correct?
Yes.
You don't know which one's his dominant hand, right?
No.
You don't know which one he trains with, right?
No.
You don't say any of that in your report, do you?
No.
So then the fact that the gun goes from one hand to another, that's going to cause a delay in the cadence, correct?
Yes.
Okay. Then trying to shoot at a moving target may cause a delay in the cadence, correct?
Possibly.
Okay. So you never put any of those things in your report when you told ladies and gentlemen of the jury about the 11 seconds, right?
I did not.
Okay. Now, you wrote about knives, right? You remember writing this? That a person with a knife would win every time against an officer who is holstered within 21 feet, correct?
Yes.
Okay.
In context, could get to the officer and injure him before the officer could bring his weapon to bear and fire a shot.
And you specifically said 21 feet, correct?
Yes.
In that case. So you're going to say a person with a knife is always going to be able to injure or get to someone before the officer is going to be able to unholster their stuff, correct?
Yes.
Right. In this situation, my client was seat belted in the front seat, correct?
Yes.
So my client at some point had to undo the seatbelt, correct?
Yes.
Reached for his holster, right?
Yes.
And at no time was she ever away, Ms. Castleberry was never more than 3 or 4 feet away, correct?
Yes.
Let's talk about the door, okay? The door being open. I understand that when you review this after the fact, it's clear to see that the car door was open, correct?
Yes.
In every single statement, in every single thing, you understood that my client believed that the door was shut.
Yes.
Okay, and so the analysis has to be from his perception with regards to that, okay, right?
But you can't ignore what you see. That's, I mean, that's
Okay,
objectively
absolutely.
apparent.
So was it objectively apparent to him when he was in the car that the door was open, Mr. Patrick?
I can understand that he wasn't aware of it, but he had to open it.
And do you think he opened that based on, hey, geez, let me open the door and do this, let me do this? Or do you think that he was reacting to a deadly threat? Okay, that's probably more likely, right, sir?
Well, I think opening the door was definitely a reaction.
Correct. So the fact that he didn't know the door was open, you have to take it from his point of view, correct? That's a fair statement.
It's understandable, as I said, but you have to look when you examine and assess the incident. You have to look as to whether that, is a mitigating factor or not.
Of course you do. But in my client's mind, he did not know the door is open. So you can't take cover if you don't know the door is open, correct? You can't reposition yourself if you don't know the door is open, correct?
If you
It's
think-
okay to say correct,
Yeah,
sir. Okay.
if you open the door, I mean, I understand he didn't realize it was open. But to say he couldn't take cover would imply that he couldn't open the door.
No,
Now, he may not have thought of it, that's fine, I understand that.
in order-
But he could have.
Don't speak over each other.
In order to take cover, you have to know the door is open, correct?
Or open it.
Correct. But he can't, if he believes that he's in an enclosed space, is it reasonable to believe that Donna Castleberry is more of an immediate threat, correct? Eminent threat.
Yes, in that
Okay.
closed space.
Okay, so you have to, you're not saying he's lying that he believed the door was closed,
No,
right?
I'm not.
You're just saying, hey, as I see that, the door is open, right?
Yes,
You realize that when he had his first interview, he didn't know that Donna Castleberry rolled down the passenger side window, right?
yes,
You saw that her put the handcuffs out the window, right?
yes,
That's her resisting arrest. That's her escalating the situation, correct?
I've agreed all along she resisted arrest.
And she escalated the situation,
Yes.
correct? And you've testified and you've written in your book many times that the best use of justified deadly force is preemptive in nature, correct?
Yes,
Okay. Because if it's timely enough and effective enough, the goal there is to prevent the risk of imminent injury, correct?
to prevent the risk of actual injury.
Right. Here we have an actual injury, correct,
Yes.
Mr. Patrick?
Yes,
And it wasn't prevented, correct?
no,
And it's reasonable for him to believe that he's going to have another injury, correct?
yes,
So, Ms. Pritchard asked you, your analysis of deadly force, a law enforcement officer must look at what the officer knew or reasonably believed at the moment the decision was made to attempt to use deadly force, correct?
yes,
So, let's apply it to here. At that point in time, he knew that, Annie Mitchell knew that Donna Castleberry had resisted both verbally and physically.
yes,
He knew at that point in time that she had committed a felonious assault on him.
yes,
Okay. He knew at that time that she had seriously wounded him, correct?
yes,
He knew at that time that he had been the recipient of being choked and almost losing consciousness, okay? Right?
yes,
And he knew at that time that she continued to use force against him in that struggle, correct?
yes,
And he believed at the time that when he went to use deadly force that the car door was closed, correct?
yes,
In deadly force standards, sir, I think you said it very succinctly, a subjective belief that imminent fear of great bodily harm, correct? That's the first prong.
I'm sorry,
The deadly force standard that you opined to earlier in the direct. First prong, a subjective belief that the officer has an imminent fear of great bodily harm, correct?
yes,
Okay. Second prong, that the decision to use deadly force is based on reasonable and totality of the circumstances, and it's judged from the perspective of a reasonable police officer in the shoes of Andy Mitchell of what he knew at that time, believed at that time, and the totality of the circumstances, correct? Okay. And that's based on Graham v. Connor, correct?
Yes, that's yes.
And Graham v. Connor basically gave us 3 factors, right?
Yes, but they're not exclusive. They are,
Absolutely not. But those are 3 things that, when you analyze the use of lethal force, you're supposed to look at, correct?
yes,
Okay. And they were severity of the crime at issue, right?
yes,
Whether or not the suspect poses an immediate threat to the safety of others, correct?
Yes.
Or that person or others. Third, whether the suspect is actively resisting or attempting to evade arrest.
yes,
Okay. So we have all those three things here, right?
yes,
Okay.
in the front seat.
All right, so when you weigh those factors, we have all of those, right?
Yes.
Okay. So then, as you know, because you and Mr. Scanlon testified, and State v. White then gave us an additional issues or factors to analyze, correct?
Yes, although I'm no longer familiar with the case.
Okay. If not, I'll go. So some of the additional factors are the suspect's demeanor has to be addressed.
Yes,
Whether the suspect was intoxicated or non-compliant, right?
I don't know. I mean, I have no reason to argue with you, but I'm not versed in the White case. I don't know what the final ruling was. I haven't read it. And if what you're telling me is so,
Sir, I'm not here to trick you.
not saying-
In State v. White, they list more factors. And the factors that they list that you're supposed to review are whether the suspect appeared to be or is violent or dangerous, the duration of the confrontation, whether it occurs during a chase or an arrest, and the possibility that the suspect may be armed, and the size and stature of the parties involved. Do you remember
Yeah.
hearing those topics?
yes.
Okay. And, may I approach the witness, Your Honor? You have a,
You on the right card, Lou?
I'm going to approach you with what's been identified as Defense Exhibit 23. May I approach the witness? Mr. Patrick, this is a copy of Graham v. White, and I turned it to the factors that are outlined. If you just kind of take a look at that.
Graham v. White, is that a different case?
Nope, nope. State v. White. Graham crackers is something different.
I was like, oh, I've never heard of that case.
Yes,
Okay.
and I think that's a sound ruling.
Sound ruling. Of course, because you testified. Not just Steve. All right, so let's go over these factors now that are a combination of Graham and State v. White, okay?
Okay?
So the first factor that we have is, and I'm sorry, quick, and I have it up on the screen. Is it on your monitor too?
Yes,
Okay, the severity of the crime at issue.
yes,
Okay. You would agree with me that a knife is a deadly weapon?
yes,
You would agree it can cause death, serious physical injury, correct?
yes,
And in this case, it did cause serious physical injury, correct?
yes.
All right, a felonious assault was committed on him, correct?
But I'm sorry, I would read this as the severity of the crime at issue being the predicate crime that brought in this case, would have been prostitution.
I understand, but there's also, you can view it from the viewpoint of the crime that was put upon the officer, correct?
But that comes, and in terms of making a reasonable judgment as to whether there's risk or not, the severity of the crime at issue here was prostitution, not assault or armed robbery. So all I'm saying, there's no question that danger can erupt.
Right.
But as a predicate violation, which is what this is speaking to,
100%, 100%. And you explained that to ladies and gentlemen of the jury. If someone was on child support, you would approach them a different way than if you had dealt with
Yeah.
someone who had been violent before.
they might still assault you, but
Absolutely. What I'm saying is, because the attack already occurred, that's that you know that you know it's a situation that the severity of crime at issue. Make sense?
yeah,
Okay. Second one, whether the suspect poses an imminent threat of safety to the officer. We have that here, correct?
yes,
When you view the factors. Whether the suspect is actively resisting arrest or attempting to evade arrest. We have that here, correct?
yes,
Fourth, the suspect's demeanor we have to look at, correct?
Yes, it was resistant.
resistant, intoxicated, high on drugs, correct? Were you aware that the amounts were high levels and that they were taken either 5 minutes before she came into contact with Mr. Mitchell, up to 3 hours before?
No, I wasn't aware, but
Okay, all right. Donna Castleberry's demeanor, she introduced the knife into the equation, correct?
yes.
So that would go under demeanor, right?
I would put that under item 2, frankly.
Okay.
Not demeanor. I mean, she brought the weapon to the confrontation.
But she's the one that took it and it was hidden. She took it,
Yes.
opened it, and used it.
Yes,
So in defense of others, if you and I are having a fist fight, whoever brings in the knife, that's not allowed, right?
that's not,
That's not allowed, right?
well, I'd prefer it weren't.
Correct. We both would. And so her demeanor was, she was the violent person at first, she was the aggressor, correct?
Yes,
Okay, so we have that. Whether the suspect was intoxicated or non-compliant, yes.
Yes.
Yes to both. Whether the suspect appears violent or is dangerous, you would agree with me, she was both violent and dangerous?
initially, for sure.
Initially, for sure.
But once she was in the back seat, that's where we would differ.
We would differ, but you don't know what she was doing in the backseat, do
No,
you?
neither do you.
But my client perceived she was still a threat, correct?
Yes,
And that's reasonable, correct?
maybe.
The duration of the confrontation, right?
Yes,
I think you mentioned a couple times in your report, 42 seconds or 47 seconds, correct?
I think it went longer than that, actually, but yes, it was a fairly, relatively long duration.
And that confrontation can take a toll on both people, correct?
Yes,
Okay. So we have a long duration. Whether it occurred during an arrest, we have that here.
yes,
Okay. The possibility the suspect may be armed, that's a definite.
that became apparent, yes, but it was, again, that goes back to the predicate.
Yeah, I understand. And the size, the stature of the parties involved, right?
Yes,
Okay. And Ms. Castleberry is smaller than my client?
yes,
Okay. And in terms of the size and the stature, Ms. Castleberry probably a little more agile than my client, right?
I reserve judgment.
More than me, right?
Yes.
Okay. And my client was in a seat, buckled in a seat, correct?
Yes,
And it doesn't matter the size of the person when they have a dangerous weapon in their hand, correct?
correct,
A juvenile, the smallest person, or anyone can inflict serious physical injury or death with a knife like that.
yes,
Okay. And then the last one that they tell you to look at, and it's not, the list isn't exhaustive, is the number of suspects. And here we only have one.
yes,
Okay. So out of there, other than we only have one suspect, all 10, you would agree with me, have been met in this analysis, correct?
those are all factors that need to be taken into account.
Right, okay. And you didn't go through all those factors in your report, did you?
I did not.
May I have a moment here?
May?
Mr. Patrick, I appreciate your time and being here, and thank you for, welcome to Columbus, appreciate you.
Charlie, do you need a break? You good? Any redirect?
Bear with me for a moment. I want to clarify something because I think it's been muddled here. When you say moment of decision, we're
Yeah.
talking about the moment you pull the trigger, right?
Yes,
Okay.
it takes an intentional act to fire the gun. That intentional act is the moment of decision.
And I thought we addressed this before, but you mentioned reasonably necessary. You're not saying that's the standard, right?
Correct.
You're applying the
Correct.
Graham standard.
Yes,
Very good. There was mention that you never talked about the choking in your report, but can I refer you to page 5?
okay.
Third paragraph, not the third full paragraph. Take a look
Yeah.
at that and tell me, did you in fact mention the choking?
Yes, I did.
And you start out your report, pages 2 and 3, don't you, just reciting the facts? Would
Yes.
that be accurate?
Yes, it's, yes. Merely my determination of the facts and sequence of events and
So
what
is your
happened.
statement on page 2, Castleberry did not believe he was a police officer, stating the facts based on your review?
Yes,
When we're looking at this objective review, we don't have to take Mitchell's word for it, right?
correct,
We don't have to believe everything he says.
correct.
The discussion about the choking and those things that occurred, did all of that occur before the moment of decision?
Yes,
So what we're really needing to focus here on is what happened when he turned and began to pull that trigger. What was happening then?
yes.
And before, from the moment of the purported choking to the moment of decision, was there a time lapse? Did things happen in between that?
Yes.
Is that when the door opened?
Yes, the door opened. She moved into the back seat. That all took time.
Did he undo his seatbelt?
I think he had to.
Did he pull his weapon
Yes.
from his holster?
Yes,
Mr. Collins said to you he never saw the knife. Do you recall objective evidence on that video of him declaring she has a knife?
yes.
Would that suggest to you?
It may, well, either he saw it or he realized he had been injured and made the assumption it was a knife. Either one would be logical.
Mr. Collins was indicating that she was a threat from the time she cut him and choked him until she moved to the back because she'd been a threat earlier. Was there any evidence that Donna Castleberry had any other opportunity to do anything else in that vehicle?
Not that I saw.
Did she have any choice to move anywhere to get away from him?
That was the farthest point she could get, was the rear seat. The doors were locked and the side doors were blocked.
So if she is a threat because she had cut him and choked him, if she is still considered a threat, in any part of that car, then does she have any chance? Is she a sitting duck?
It would, I keep saying, it all depends on what she does. And we have limited knowledge as to what she did. We have the soundtrack, we have Officer Mitchell's statements. But she had no escape. I mean, there was no way she could get out of the car. And I do ask what she would have had to have done to not get shot. You know, and how could she manifest that? How could she manifest giving up and surrendering other than what she did?
And if Officer Mitchell is aware that there are child locks and she's trapped in the car, then would an experienced officer reason that she has very limited options to retreat or surrender?
He should have known, I would think he would have known that, yes.
And I believe we clarified that from the time he was cut until the shooting, I think about 45 seconds, would you agree?
Yes.
So what happened when he was cut is irrelevant to what happened at the moment of decision when she was in the back seat, right?
If she continued her attack, no, it would be highly relevant. If she didn't continue her attack, no, it would not be. And I saw no evidence. I mean, he suffered no further injury. He was clearly vulnerable to attack. Excuse me, he was vulnerable to attack when he let go of her hands to draw his, get his weapon out. He was vulnerable to attack when he was still in the front seat with her in the back seat, which again goes back to, it might have been more advisable to get out of the car. But he suffered no injury, there's no damage to the upholstery, there's no indication whatsoever that she was lunging and slashing at him with a knife after she'd moved into the back seat.
So we're using the objective review, and would you agree with me, it's the jury's province to determine factually whether we
Objection.
believe?
Basis?
May we approach?
Yes.
So the facts as they exist and the believability as to what happened isn't what you're reviewing. That's for the jury to review.
Yes.
You're making the objective review and your opinion based upon your experience, looking at the objective factors without assessing whether or not what somebody said is believable or not.
Yes.
Thank you. There was discussion about your book and the intent of the officer and the intent of the suspect, and I think you said that that can't be known.
Yes.
How is that different from an officer considering the words of a suspect in an interaction to determine if they're a threat?
Well, officers have to consider what they're being told and assess it within the circumstances of whatever the confrontation is. They're trained to listen to the people they're interacting with or having a conflict with, but then they have to make their own judgment as to whether what is being said is believable or not, because they can't know what somebody has in their head.
That is something the officer is listening to and considering.
Yes, and, considering it in light of the circumstances, the event, whatever, as much information and experience with that individual as they've got.
You were referred to toxicology reports and narcotics in Donna Cosperry's system.
Yes.
Was there any evidence that Mr. Mitchell knew that at the time of the offense?
Not that I saw.
Was there any evidence that he knew that she had a good warrant at the time of the offense?
No, I think he was he was asking her if she had a warrant, and if he'd had communications, I'm assuming he would have checked that.
So if he didn't know that at the time, does that factor into the analysis at all?
Not for me, no.
Was there any information that you recall reading where he said, oh, she was acting like a crazed person on drugs?
No.
So that didn't factor into the list of factors here about intoxication or things like that. That be fair? If not known to him at the time.
Yes.
And whether or not she was dope sick or trying to score dope or anything like that, does any of that, if not known to him, affect what happened when she was in the backseat and shot?
No.
Mr. Collins asked you if her intention might be that she was trying not to go to jail.
It may have been.
Might her intention, based upon an objective review, been that she was trying not to get raped by somebody she didn't believe?
I'm
Also,
going to object to the leading question.
Sustained.
I mean, We approached once, Your Honor, and it just,
No
We approached
speaking-
on a
No
series.
speaking objections. Can ask the next question.
Might there be more than one explanation than not wanting to go to jail?
Yes.
There was a discussion about warnings not being required, and I think you agreed they're not required.
Correct.
And I didn't quite catch the rest of your answer. I think you said something they're typically seen. What were
Well,
the-
it's unusual for police officers not to verbalize in confrontations. That's all. They're not required. They definitely aren't. But officers are trained to give commands. They're trained to tell people what they want them to do. And in fact, there's situations, arrest scenes where there's more than one officer involved. Sometimes you have too many officers telling them what to do. It's characteristic of arrests that officers are issuing commands and telling them what to do.
So while something might not be required, it's often seen, or it's good practice, or
Yeah.
it might,
objection, Your Honor, leading.
Overruled.
Correct, yes.
thank you. You saw the pictures of the vehicle in this case, right?
Yes,
And you saw video of the vehicle, right?
yes,
And you know what a four-door vehicle looks like, right?
yes.
Was there any way for Donna Castleberry to be more than 20-odd feet, arm's distance, I forget what the terms were, within the compartment of that car? Did she have any choice to be any further?
No, she was restricted to the confines of the car.
Trying to read my own writing, I apologize. Do you recall whether or not Mr. Mitchell said he saw Ms. Castleberry at any point in the back seat with the knife?
Once again, Your Honor, objection, leading. Sorry.
Overruled.
I-
I think he knows.
I don't recall him saying he saw her with the knife in the back seat.
There was some reference to whether or not Ms. Castleberry was an aggressor, and I believe you said she was aggressive or aggressively resisting.
Yes,
Is that your terms? Do we need to look at the perspective of the person to determine who we want to call an aggressor?
Again, objection, Your Honor, leading.
I'm going to sustain that.
Is there a difference between being aggressive or doing something aggressive and being an aggressor?
I think we're getting into semantics. Aggressive people aggress. I don't,
Okay.
yeah.
That's fair. Is there more than one interpretation based upon an objective review of the video?
Again, Your Honor, objection, leading.
I hadn't finished my question anyway.
Well, let her finish the question.
I'm sorry, Your Honor, what?
Finish the question.
Oh, thank you. An objective review of the video, is there more than one interpretation as to whether or not Donna was an aggressor, if we look at it from a different perspective, her perspective?
I'm not trying,
Am I not being clear?
yeah, I'm not clear on what you're asking, and I don't think the video allows that nuanced an interpretation either way.
If this had not been a police officer in this case, would Donald Castleberry have a self-defense claim?
Objection, Your Honor.
Sustain.
Move to strike, Your Honor.
We'll strike the question.
Whether or not Donna was moving in the back seat is a factual determination. Would you agree with that?
Yes.
So what she's doing in the back seat is not subject to the objective reasonable standard.
I'm not
Is it-
sure I understand your question.
When we look at what she's doing in the back seat, we're determining that factually, correct?
Yes, but if you make a determination of what she did in the back seat, that has to be part of the objective examination of the decision to shoot.
Agreed. You were aware of the hand injury he sustained, right?
Yes,
And you still found the shot cadence problematic, is that what you're saying?
yes.
You said, I believe, there was no objective evidence he was cut again, correct?
After he was injured, hand injury, I saw no evidence that he suffered any subsequent injuries, cuts, stabs.
Okay. Did you then consider that objective evidence that she was not a threat anymore when in the
Objection, Your
back?
Honor. Leading.
I'll sustain that.
Why did you find it significant that he'd never been cut again?
Objection, Your Honor. He didn't testify that it was significant.
I'm gonna overrule that if he testified to that.
When you're within arm's reach of somebody attacking you with a knife, you're gonna get cut. No matter how adept you are at fending it off or controlling or handling the nut, you're gonna get cut. And you're gonna get cut more than once. As long as the attack continues, you're gonna get cut. You may win the fight, but you're gonna get cut. Once he let go of her hands, he no longer had any, if she were still attacking him with a knife, he would have been cut. As his hands were otherwise engaged, getting his weapon out, releasing his whatever. He suffered no further injury.
And there was discussion of the door being open, and I think you said you see that on the video
Yes,
objectively.
yes.
And the fact that he doesn't remember it, you didn't get to finish some of your answers. The fact that he doesn't remember it, is that significant?
Not to his decision-making process. That's the kind of thing I would look at in a post-incident review and say, look, these are lessons to be learned here. This is what you should have done, but that doesn't speak to the reasonableness of the decision to shoot or not.
And when Mr. Collins went through the list of factors, did you say all of those factors existed in the front seat?
I don't know about all, I'd have to look at them all, but predominantly, yes. The factors that exacerbate the situation and are important to assess the threat, the imminence of a threat, existed in the front seat, yes. And then in the back seat, that somebody has to make a determination what she was doing in the back seat.
And if an officer gets tired, does that allow him to use any more force than he would normally be allowed to use?
Again, it's a matter of what's reasonable. I mean, being tired or fatigued is a factor that an officer may have to do something that he wouldn't otherwise because he didn't have the strength or the ability to follow through. And if the circumstances support that, then it's reasonable. It's not something you can just say it is or is not. You have to look at it within the circumstances.
So, in the end, your opinion here as to this being unreasonable stems from which moment in time?
At the moment he decided to shoot. When she was in the back seat, she was, again, the lack of injury, the lack of signs of a continued attack tell me that she was quitting, she was submitting, she was trying to get as far away from him as she could, and she was giving up.
Throughout your career, you said you've testified against an officer. This is the second time?
Objection, Your Honor, again, outside of.
Let her finish the question,
Okay.
Mr. Collins.
This would be the second time you've rendered an opinion like this?
Once again, objection, Your Honor, outside the scope of cross and asked and answered, move to strike.
Overruled.
Yes.
Do you have anything to gain by testifying here?
Objection, Your Honor, leading.
Sustained.
Nothing further.
Very briefly, Your Honor. Mr. Patrick, couple things that you just said. I want to start with a big concept, you can't see anything that happens in that back seat, correct?
That's correct.
We had a video expert here testify that he can see no details of anything in the back seat.
Correct.
So we have no idea what she was doing in the back seat.
Correct.
We have no idea if she was a threat or not from our vision, correct?
Correct.
But this has to be analyzed from my client's perspective, correct?
And corroborated by what evidence we do have.
Absolutely. And you mentioned something with regards, I'll get to that. I want to talk about these factors for a second, correct? And I apologize if you thought I was indicating something not. First one with regards to, look at that, I waited. Number 5, whether the suspect's intoxicated and non-compliant.
Yes.
Non-compliant can be as a result of being intoxicated, correct?
Or not. I mean, people are non-compliant or stone cold sober.
Absolutely, but there's a reason that they put those two factors together, correct?
Yes.
Now, severity of the crime at issue. We're not saying, you don't believe that I said that, Andy Mitchell didn't try to kill her when he was putting her under arrest, correct?
Oh, of course not. No.
He didn't try to kill her for prostitution.
Severity of the crime at issue, again, is the predicate crime that led to the confrontation. The fact that an officer gets assaulted later on is not severity of the crime.
My question to you is, Andy Mitchell didn't try to use deadly force when he was placing her under a lawful arrest for prostitution, correct?
Correct.
All right. Now, you were aware of the lead detective in this case, correct?
Yes.
Detective Shepard, right?
Yes.
And you were aware that pictures were taken, and you reviewed photographs of the car, correct?
Yes.
And you were aware that pictures were taken of my client's hand and other pictures at the hospital, correct?
Of
my client at the hospital.
Yes.
And you were aware that Detective Shepard took 2 pictures of defensive wounds on my client, correct?
Yes.
No, but you just said there was no other injury. There were knife cuts on my client's other hands from the result of this situation, correct?
Yes.
So that goes against what you just told the ladies and gentlemen of the jury, that lack of other injury. He was injured other than the slashing, correct?
He had another injury on his other hand.
Other hands. So are you lying to the ladies and gentlemen of the jury?
I am not.
But you didn't take that into account in your analysis, did you? Of the lack of injury, correct?
I did. There was no injury to his arms, to his torso. I
To
think
his toes? No injury to his toes or anything like that?
Sustained.
There was, in fact, other injuries he occurred from that knife, correct?
Yes.
And you don't know when they occurred, correct?
I don't.
And it's reasonable to believe that they occurred after the initial slashing, correct?
It's also reasonable to believe they occurred at the initial slashing.
But again, you told the ladies and gentlemen of the jury that one of your big prongs of this analysis was that there was no other injury to Mr. Mitchell, right?
Yes.
And you are 100% wrong about that, correct?
I don't agree with you, but
Wait.
he did have a second injury,
My
a
question,
minor injury.
my question is, you told the ladies and gentlemen of the jury that because there was a lack of any other injuries, when you're in a knife, when you're in a struggle with a knife, there should be other injury. there's corroboration and physical evidence of another injury in this confrontation, correct?
Yes.
So you are 100% wrong, correct?
No.
Okay. No further questions, Your Honor.
All right, you can step down, Mr.
Thank you.
Patrick.
Thank you.
Leave everything up there, other than what you brought. Council, one approach?